I need to mention an application for
Application, yes.
in connection with first
Yes, yes. Application.
admission of
Yes.
Madam, permitted to for direction for preparation paper book. LC
You
receive.
want an order for that? An application or?
No, first time only to be mentioned. Last
Right.
order was that whether preparation of paper book should be.
If it appears to be mentioned, just give the caption to be mentioned in your sleep. Yes.
Can be permitted to
Yes.
mention, my lord,
I'm good.
for inclusion.
What is the matter?
This is the matter of second appeal. Earlier it was
For order for an admission?
yes, madam.
Yes.
My lord, may be permitted to mention
Under
one matter-
order 41 rule 11.
permitted to mention one matter for hearing, my lord. This is receiver's application was rejected, my lord.
Hearing of the appeal?
Appeal, my lord.
No.
Another is preemption.
No appeals right now. Yes.
I will just need to mention this matter for extension of interim order
Yes.
and for filing paper books. But the only difficulty is, the time is expiring tomorrow. But we could not mention.
No
it is our fault.
difficulty in that. We'll look into that.
I'm grateful.
Hand over the slip. Yes, yes.
We are permitted to mention one matter for inclusion.
What is the matter? Application?
Second appeal, admission for appeal.
Yes.
application. Why is not
Application
getting,
handle. Application.
alimony?
This is hearing of appeal.
Forget.
One more thing, this is a small point, short point, very short point.
Even short points.
What I say,
Just see the short points. Sit over the sit in this court throughout the day and see the short points. We'll take up appeals today first. Just have a seat somewhere.
Paper books are already
No.
all done.
Call on the list.
Number 1.
Yes.
Whatsoever I was mentioning this matter for inclusion. There is a
What is the matter?
for
You have called item number 1. You should have mentioned it. No, not now. Come back. Some other. Yes.
I appear for the respondents in the matter, my lord.
Why is it
For
appeal?
instance, the matter has appeared as
Yes,
you
why?
mentioned. My lord, it's an appeal against letters of administration granted in 2008. And by virtue of the pendency of this appeal, my lord, I'm unable to enjoy my property. It's dilapidated in a dilapidated condition. There's a stay not to deal with the property in the appeal without the leave of this court, my lord. But I'll beseech your lordships to fix the matter on any day as per the convenience of this court, my lord.
It's an appeal hearing.
It's an appeal.
No. You can file an application if you want to repair the premises, but no.
But because of the pendency,
Dilapidation is not a ground. The court's list is in any event dilapidated,
the
crumbling.
lordship fixes the matter next month.
No, not now.
It's a 2008 matter, my lordship.
Even then. Next.
May I take out an application for that? That liberty is already there, granted by the court.
Yes, without that also you can file an application for repair or some other thing. Yes.
Well,
Dilapidation can be taken care of, but hearing not right.
okay, my lord.
Oh, acha. No order need be passed at this point of time.
Item number 2.
The respondent number 3.
Yes. Mr. Dhor was going to add something. Let him finish and then we'll come to you, Mr. Rai. Yes, Mr. Dhor, what were you going to add? Please take your seat, Mr. Rai. We'll just. Yes, Mr. Dhor.
Page 123.
So Dhor, you had cited 2016-15 SCC. You had cited this as 2016-15 SCC. Modina Begum.
2016,
Yes, yes.
part 50.
Yes, that is what I was. Yes. Let us come back to page 123. Yes. Yes, 123.
Paragraph 3.
Page 123 you are saying?
Yes, paragraph 3.
Yes, third paragraph. Yes, the agreement.
No, this is not the agreement. This is the.
It starts with the agreement. The sentence starts with
Yes,
the
yes, yes.
agreement.
the agreement made between
Not telling pages.
no. The agreement made between Prashant Kumar Chakraborty and my father. Actually, due to impression, and my father, Sukumar Doctor, was written in English. And the agreement made between Ashok Rai and just a minute.
Yes. If you want to have a glass of water, you can. No difficulty.
Madam.
Yes. Read the paragraph written in English, but he had no knowledge of English.
No knowledge of English.
Right. So you've
There's
understood.
no knowledge of English.
Right.
Even with these two, the two agreement, both the agreement, one between the plaintiff and the original owner, and other one with the developer.
This is the cross-examination.
Original owner and the other.
Yes, this is the cross-examination of which witness?
Cross-examination of DW
DW2. Right.
DW2,
Yes.
the defendant number 3,
All right.
respondent number 3 before your lordship.
All right.
She is admitting the existence of the agreement. And this has been recorded by the learned trial judge, but he did not come into the merit of the case. He has dismissed the suit only on the point of limitation, the preliminary issue.
All right.
But the 2016 part 15 SCC,
Other issues also have to.
other issue should have been considered
Yes.
by the trial court and also by the honorable High
Yes.
Court.
What was the paragraph you relied on?
That paragraph 17.
17. Actually,
Paragraph 17 to
we find only the first page of that judgment. Can you give a complete copy of the judgment? Only one page.
yeah, only.
Yes, give a complete copy. 2016-15 you can get from somewhere from the library. Just give a complete copy. You finish your arguments right now. Later on in the day, need not place the book. Need not place the book.
at first.
You have placed it. Need not. Modina Begum and another.
Modina Begum and another. And Sikh Murti Prasad
If he searches by Modina Begum, he'll get it. 2016, 15 SCC, 322.
320.
Yes. What next, Mr. Dhar? This is all. So you say that the agreement, the deeds existence are admitted.
On cross-examination.
Yes. In court.
Initially in her written statement, she said there is nothing. No agreement, no payment, no possession.
All right.
But all this has been admitted and executed, and possession has been handed over by the original owner.
All right.
Even the limitation portion also properly performed by the original owner and the plaintiff. Out of 1,05,000, 1 lakh was paid, and 5,000 was to be paid at the time of registration. Only this 5,000 become due. The deed was made ready within 1 month from the date of possession.
Right.
One point, my lord, which list of dates I have handed over to your lordship.
Yes.
Only the date of execution of the agreement has been wrongly printed out. It should be 16/10/2016. 95.
It has been written 1410.
14.
Very good. We'll correct it. We have correct. Yes. So this is all, Mr. Dhar.
I have also verified others and all are verified.
So let us now hear Mr. Yeah.
I have also submitted on the last occasion that PW 1, 2, 3 and DW1 admitted. DW1 and PW2 admitted that entire transaction has been done in their presence. They are the eyewitness.
DW?
DW1,
Yes.
the son of the owner,
Yes.
and the promoter,
He was DW.
that Ashok.
He was DW.
He is a PW. Ashok.
PW 1 to 3 and DW 1
PW 1 to 3
and DW 1.
DW1.
Wait.
That Ashok Rai, the promoter, he has also admitted and he has been cross-examined also.
Good.
In all the occasions, they have stated that it has been done. All performance has been done in their presence.
That's all, Mr. Dhar.
The,
Yes.
the confusion arose in the mind of the learned trial judge from the agreement that within 6 months, from the date of agreement, it was to be, the possession should be made over after completion of the building.
That you have argued.
Mistakenly, he has taken
You have
that
argued at length.
it was to be executed, but it was to be executed in paragraph 2 of that.
You have argued at length, Mr. Dhar. We have noted. Thank you. Yes. Yes, Mr.
Lord, my lord, Lordship takes the trouble. I have just checked up. I want to place the matter from original only 2 documents.
Yes. ওনাকে একবার রেকর্ডে মিস্টার রায় would you be kind enough to find those out?
Yes, I have marked it.
Wait.
I have
So
come,
we'll look into it.
just my lord showing 2 documents.
Are they not parts of the paper book?
Paper book, my lord, is not reflected. The way it has been drafted, way interpolation has been made,
আচ্ছা
it is not there. That's why.
you want to show the original, right?
Yes, my lord. My lord, kindly lordship, I have these 2
The pink ones?
pink one.
Yes. ওটা একটু সাবধানে দেবেন ছেড়ে না পুরোনোটা অ্যাপিলটাই তো 2007-এর First one is 16th October 95.
This is the agreement
Yes.
which they are intending to execute, my lord, or performance.
Right.
My lord sees the nature just for a while, how it has been done. See lots of interpolation right from, have you lordship got it?
Yes.
Number of interpolation.
There is a short signature in the first
Yes,
inter.
that's there. That's there. my lord.
Oh, আচ্ছা কিন্তু curly bracket is also there in the second.
Yes, yes. And next, my lord, next another thing, lordship, kindly see next. It is also one of the see the, my lord, the first agreement between the parties and the conveyance, next conveyance. Who are the parties?
সুকুমার প্রশান্তের মধ্যে একটা পরেরটা হচ্ছে
Here, my lord, will find a new name, Munmun Chakraborty.
no the date is not there.
Even agreement same agreement, conveyance to be prepared in the name of Moonman without any date. Lordship kindly sees. I have just tried, Lord. I also wondered what is there.
But this is the original exhibit,
Yes.
exhibit 5. What was the previous exhibit? Will just note 3.
Exhibit 5, Exhibit 3. দুটো দেখালাম।
97. Exhibit 5 is 97 document, but the date is not there. And there's a whitener over the month also.
And the person is Munmun Chakraborty. My lord, see the name of the vendor, Munmun Chakraborty.
Gita, heirs of Sukumar,
Yeah, and with
Munmun Chakraborty,
Munmun Chakraborty.
wife of Prashanto. So not Prashanto.
Not
And Prashanto was alive, obviously, because wife of
yes,
Sri
yes,
Prashanto.
yes.
Heirs of Sukumar we can understand.
Yes.
Because
I
Sukumar.
understand, yes. Yes, of Sukumar understand.
Yes.
Then Lordship kindly turn to Lords. If the argument is made on a short campus, the yes, as per Article 54, from the date,
Hmm.
3 years.
Hmm.
Maximum period 3 years. If the agreement is interpreted in a way, Lord, nothing to be argued. But I would submit to your Lordship, if the agreement interpreted, then it has to be from the date. Date inclusive of 6 months. I will come to this plot later. Then Lordship turn to page 34. How the things are. I have shown 2 documents I have seen.
Now, shall we return these?
Yes.
Because we have seen
I'm
whatever
just only on this part.
on this one. Give us half a minute. Oh. Okay.
It is super basic. Page 35, paragraph 2.
Yeah.
For the
Paragraph
Sukumar Datto entered into an agreement for
Page
joint.
35 is a written statement.
No, my lord, in my copy, my amended plaint starts from page 34. Amended plaint.
Not in our copy, it's different. আমাদের amended plaint কোথায় আছে?
Amended plaint on behalf of plaintiff filed on 3rd May. Have you also got it? 3rd May 2006.
We are trying to just find out that amended plaint in our copy is at page 25. 25. Anyway, we've got the amended plaint.
Yes. Plaint is there, amended plaint is there. Lordship kindly take the trouble to see over, it is written at the top, amended plaint.
Yes.
Yes. Lordship kindly turn the next paragraph 2. Sukumar Datto entered into agreement with joint venture with Ashish Kumar. Before that, Lordship kindly takes the trouble for see the prayer, page 40. What he is intending to, page 40. In paragraph after paragraph, it is why the page is not telling. I don't.
Page is not telling. Anyway, we have found the plaint in our copy, page 31.
Page 31. The plaintiff prays for a decree.
Yes.
For specific performance of the contract dated 12/6/95 and 6/10/95. 16/10/95.
Yes.
Against the defendant number 3. directing her to execute such and such on payment of 1/3 portion. Therefore, my lord, you will find two agreements supposed to be there.
Hmm.
If that be the position,
Hmm.
whether it will go back to 12,696 or not.
But if there's a subsequent agreement, why should that not
Yes,
prevail?
and that's true, my lord. They are carrying that. They are carrying that. At least I can say they are carrying that period at least. At least they are carrying that period for the purpose of performance.
But the moment, Mr. Rai, a new agreement is entered and the previous one is given a go by, that's the fresh.
New, I will go back, show them, my lord, that they are carrying the same payment. Had it been a case, new one, new payment, I could have understood. They are carrying the backdated.
So 1610 refers back to that previous one and
Yes,
all.
yes, yes.
All right.
Then first paragraph, one, ownership, I am skipping over. Then second paragraph, the said Sukumar, have you also got it?
Got it. Yes.
Sukumar Dotto entered into an agreement for joint venture with such and such on 3rd August, only kindly, 3rd August 1995.
Hmm.
Already constructed. Paragraph 3. Paragraph 4.
Hmm.
The said Sukumar Dotto received is a rupees 50,000 from Prashanto Kumar Chakraborty on 12/6/1995. Why I tell me that prayer march of this date is there, 12/6/95. In presence of his sons, his Somnath Datto and Sudhir Shah and others, out of which 10,000 was for booking a garage space on the ground floor of the plaintiff on a verbal agreement, and rupees 40,000 as loan. Therefore, Miller, first one is verbal one. 12/6/1955 is a agreement verbally entered into,
Hmm.
which he required for making necessary arrangement for shifting his tenants from the premises to give vacant position to the developer for the development purpose. Therefore, there were two receipts acknowledging the said money. The loan for rupees 40,000 carried 3% interest per month and was to be repaid after 6 months, but not so repaid. Therefore, 6 months will coming from 12/6/1995. Subsequently, next paragraph, subsequently, Sukumar Dotto entered into a formal agreement, what he said, for sale of the said garage space on his ground floor at premises number such and such, Puran Chandra Avenue, Calcutta, on 16/10/95 in favor of the said Prashanto Kumar Chakraborty, and received a further sum of 50,000 as earnest money in addition to the previous 10,000 from the said Prashanto Kumar Chakraborty in presence of his sons such and such. The terms of terms exhibit 3 at page 193. My lord will be getting. But it will not tell you with my.
Oh, yes. Let us see whether one. You are trying to rely on that 16th of October agreement. You're
Yes.
trying to show that. No, 16th of 194 in our copy.
Yes, 194.
Huh. Huh. Yes, the body starts from 194 and 193 is the first.
Memorandum of agreement made on 16th October 1995. Between Sukumar Dotto, Prashanto Kumar Chakraborty. Evaluation got it.
Hmm.
Third paragraph, next 9 to 5. I am skipping everything. 196 terms. It is very vital. Now this memorandum of agreement with witness and parties had to mutually agree to the following terms and conditions. The vendor shall sell, the purchaser shall purchase the cover space measuring more than 140 square feet built up area on the ground floor of the building be made over to the purchaser after completion of construction within 6 months. Here is layout. After completion of construction within 6 months from the date of agreement. What is meaning thereby? According to my interpretation, my lord, it must come from the date of execution of the agreement. It covers everything. Completion covers 6 months. It cannot be separated.
But the presumption then would be that the construction will be completed within 6 months.
Within 6 months.
But here they say that it has not been.
According to them, this I will come. But interpretation of this clause, precisely according to my interpretation, it must carry within 6 months.
So that completion of construction is included within that 6 months.
Included within that 6 months. If that be the interpretation, my lord, my submission would be before your lordship.
Then it's time barred because 6
It
months.
is time barred. But if it is interpreted in another way,
Ah.
after this, so long completion is not made, then thing would be otherwise. But my interpretation, my lord, on the face of this particular interpretation, it is conjunctive. It cannot be separated within 6 months.
Mr. Rai, there is a line of judgments which you know. I mean, even if the parties agreed to a period, they can give a go by to that. Then it will not be the essence of the
By
contract.
implication.
By implication, by
By
their conduct.
implication.
But
By
then if the
implication.
construction itself is, if their case is taken and the construction is made after 6 months, then by implication, I mean, they made the construction after that.
Who made better?
The promoter.
Promoter. But my lord, document to be read as it
Yes,
interpreted.
all right.
Document to be raised as it stands on.
Very well.
For the purpose of limitation. Document as lordship knows court cannot extend the period of limitation under no circumstances.
No.
Therefore, submission was made that in interpretation of this particular clause, as if after 6 months, so long construction is not made, it carries, the agreement carries. My submission would be, my lord, that is not precisely the agreement about.
And 6 month, the 6 months phrase qualifies date of agreement.
Yes.
And whatever else is there after completion of construction and all.
There's another thing, my lord.
Achha. So ground floor be made over to the purchaser after completion of the construction within 6 months from the date of agreement.
6
So we
months is the
segregate 6
ultimate-
months from date of agreement.
Yes. 6 months is the ultimate date.
Very well.
Then Marshal kindly turn to, I have sought out how the payment has been made according to them. Then lordship kindly turn to cross-examination of PW1, page 81 to 85.
PW1, yes.
I am to start because it will not. Yes. Cross-examination of plaintiff witness number 1.
Yes.
Cross-examination of PW1, Prashant Kumar Chakraborty, resumed on such and such. An agreement was executed between myself and Sukumar Dotto on 16/10/1995. There are some corrections in the agreement deed with the signature of the parties. Memo of consideration has not been noted in the agreement deed. Lordship kindly mark this. There is no memo of consideration referred to in the agreement. According to that clause, on the date of execution of the agreement, a sum of rupees 50,000 was paid. At the time of agreement, Sukumar Dotto took loan from me, a sum of rupees 50,000. 2 receipts were issued by Sukumar Datta at the time of taking loan from me. Receipt issued by the here, my lord. Just I pause for a moment, my lord. According to them, at the time of agreement, he gave 50,000. My lord, plaint I have read. Plaint said that 10,000 out of 50,000, 10,000 towards 40,000 towards loan, 10,000 towards garage booking. Now on the face of this plain statement, read it. There are some corrections in the agreement deed in the signature. Memo of consideration has not been noted in the agreement deed. On the date of execution of the agreement, a sum of rupees 50,000 were paid. At the time of agreement, Sukumar Datta took loan from me 50,000. 2 receipts were issued by Sukumar Datta at the time of taking loan from me. Receipt issued by Sukumar Datta does not bear any signature of any witness. It is not a fact that the exhibit 1 and 2 does not bear the signature of Sukumar Datta. It is a fact that exhibit 1 and 2 bears no revenue stamp for the receipt of the loan, and the agreement deed is a separate transaction. Lordship, kindly mark this. It is a completely separate transaction. Therefore, payment whatever made with the loan, it cannot be quitted unless there is specific stipulation to the effect. Parties agreed, had it been, I could have understood. Memo of consideration nil.
So the loan could not be connected with the agreement.
Yes. Because my case is altogether, there is no loan, there is no agreement. This is precisely the WS is of my case, client. And the agreement deed is a separate transaction. As such, the factum of payment of loan has not been noted in the agreement deed. Therefore, my lord, payment made alleging towards loan any amount according to their cross, they are admitting it, it cannot be quoted, cannot be included. By virtue of the agreement deed, I noted in the Schedule B of the memo of agreement, one covers paid on the ground floor of the premises number such and such to the extent of 140 square feet. I did not file the sanction plan of the building. In my affidavit in chief, I have mentioned garage space along in the Schedule B of the agreement. It has been mentioned as cover space. Somewhere something, where garage space, covered space, anyway, I am skipping. Out of the 50, a sum of rupees 10,000 was given towards the consideration money of the garage space, and rest 40,000 was given as loan. Therefore, said amount of 10,000 was given towards consideration of money of the garage space has not been noted in the memorandum of agreement. That I have
Already stated.
After the death of Sukumar Datta, I sent the deed of conveyance to the defendants for execution. This is the deed of conveyance. Taking the consent of the legal heirs of the Sukumar Datta, deed of conveyance was purported to have been prepared in the name of my wife, that I have shown, Munmun Chakraborty. No written consent was given by the defendant to execute the documents in favor of my wife. In the deed of agreement, consideration money has been shown as 750 per square feet. Total value was fixed at 1,05,000. This is the purported deed of agreement. Value was, according to, though in the deed no valuation was assessed, but somehow in the prayer, in plaint they have said it will be 1,05,000. In the deed of conveyance, the consideration money has been written as rupees 75. Lordship kindly turn for a while the agreement with Moon. Just I have shown to your Lordship.
Yes.
Page 202. Page 202. No. I have referred paragraph 5. There is a blank. My lord had noticed it. And bottom,
Yes.
75,000. Lordship, have you Lordship got it? 75,000.
The paper book itself.
Where?
Page 202.
Page 205, paragraph 5. agreement with Munmun. One agreement, consideration money, though not referred, as per their case, 1,05,000. Now it has been written 75,000. Keeping the agreement blank. Name is
Yes.
Munmun. Then page 216, received. This is vital to me. Everything is received by Munmun Chakraborty. 216.
Received from Munmun Chakra.
Received from Munmun.
Yes.
Amount 75,000. Paragraph 5, just for it, 200, page 205. An agreement dated blank made between the said Sukumar Datta therein referred to as vendor of the one part in the said agreement, Timothy Munmun Chakraborty, the purchaser herein, and also referred to as the purchaser of the other part. The vendor herein has agreed to sell the purchaser, and the purchaser has agreed to purchase the room such and such, my lord, where 140 square feet together with service for a consideration of rupees 75,000 of the said.
But in the in PW2 evidence, page 82, he says total value was fixed at 1,05,000.
Five.
But shown as 75,000 in the deed.
With Munmun.
Yes, with Munmun.
With Munmun.
Yes.
And coming from the same agreement. If the agreement carries a clause, it is to be implemented. They are trying to enforce an agreement. Here is a case, my lord, if ultimately suit is declared, an agreement to be enforced.
The agreement, the consideration was mentioned.
Consideration, my lord, was not mentioned, but in their plaint everywhere, payment mode, out of 1,05,000, they have paid initially 5,000 is deficit that is to be paid. That is admitted case.
So you are highlighting this discrepancy between 1,05,000 and 75.
Yes. And the person whom the agreement was entered into, whom the conveyance was prepared, how the mode of payment was made.
All right.
Thank you. What is here? Then we will not go back to the cross-examination, what I was referring to. Is what? Cross-examination. Cross-examination. Page 81 to just I was reading the cross-examination, then with reference to that I have come here. Yes. Total value was fixed at 1,05,000. It is according to their case. Conveyance 75. Persons different. In the deed of conveyance, the consideration money has been written as 75,000 as per instruction of the legal heirs of Sukumar Datta. It is not a fact that no instruction of the legal heirs of Sukumar Datta regarding consideration money was taken as shown in the deed of issue. As per verbal instruction of the heirs of the Sukumar Datta, defendant's consideration money of rupees 75,000 has been mentioned in the deed of conveyance. In addition to that, I sent a draft copy of the deed of conveyance through my advocate to the defendants on 3/5/97. This is the deed of conveyance. The same is purported to have been executed in my name. In this deed of conveyance, total consideration money has been shown as rupees 1,05,000. 5,000. The deed of conveyance was executed in 1999. This is probably not the correct. No deed of conveyance was executed. This is not the correct one. Agreement trying to enforce how the deed can be, conveyance can be executed. Probably it is not the correct thing.
Maybe the draft deed.
Yes.
We were carrying on with the draft deed.
It
But
should-
cross-examination, Mr. Wright, is very ambiguous.
Yes,
I mean, it depends on the question.
depend on question.
So we'll go light on that.
Yes. Out of the total consideration money of rupees 1,05,000, I paid a sum of 50,000 on 12,695 to Sukumar Datto. I also paid. Therefore, my lord, 12,695 according to cross-examination, he has paid to Sukumar 12,000. Is completely destructive of his plaint case. Why I tell you, Mr. According to plaint case on 12,695, if it is assumed he paid total 50,000, out of which 10,000 was towards garage and 40,000 was loan. Therefore, my lord, both cannot go together.
So he says, I paid a sum of rupees 50,000.
50,000 towards,
He does not say towards. He only says, I paid a sum of rupees 50,000.
yes,
So
what
that may include 40 and 10.
might
It's
be,
not destructive of that. That is what I guess. He says, I paid rupees 50,000 on 12/6.
this is, my lord, this particular payment schedule is in consideration of agreement. It has to be read in as a whole. They are enforcing an agreement.
Cross-examination, we won't read into anything. That would be very risky. This person says, I paid a sum of rupees 50,000 on such and such date.
Yes,
And the plaint case is 50,000 was paid, 40, 10.
40 days.
So that is not destructive. That may be a bit in deviation from there. They don't
Deviation.
give the breakup.
To Sukumar Datto, I also paid a sum of rupees 50,000 as consideration to Sukumar Datto on 16/10/95. Subsequently, I paid rupees such and such to the defendant number 1 and 2. The defendant number 1 2 executed the deed of conveyance in my favor. It has not been noted in the agreement deed that I gave rupees 50,000 subsequently. Nothing in the agreement. No consideration money, no mention. 2 receipts exhibited. 1, 10,000. Yes, even it is questionable, but I say, my lord, 2 exhibit 1 and 2 given. Apart from 2 exhibit, no receipts. Even no consideration how it has been paid. Normally, if it is unheard of, an agreement is made.
Yes.
It must follow a memo of consideration. It must follow the which is the date and what is the mode of payment. Nothing of any sort. I have shown to your agreement. Agreement according to their own cross-examination, there is no memo of consideration. My lord, the defendant number 1 2
But the
executed.
receipts tally, Mr. Rai.
1
50,
receives 1 and 2. It says, my lord, whether it is correct, that I will submit, my lord.
on a different day.
Only one receipt.
No, the amount whether that was that
No,
that tallies
I
with
will
it.
exhibit 1 and 2. I will show. Exhibit 1 and 2 received towards 10,000. Received was 40,000. That's supposed to be on 12/6/95. No further receipts.
Or the subsequent 50,000 was
Nothing. They have admitted.
yes.
The defendant number 1 and 2 executed the deed of conveyance in my favor. It is not noted in the agreement deed that I have. Lordship kindly sees, it has not been noted in the agreement deed that I gave rupees 50,000 subsequently. This is their cross. They are acknowledging. It is not noted. Not a fact that I paid nothing to Sukumar Datto or to his legal heirs. Not a fact that I am deposing falsely. I took possession of the premises in the last part of June 1997. This is the letter, Lordship kindly mark this, June 1997. This is the letter from which it will appear that Sukumar Datto took loan from 50,000 from me on auto shifting of this tenant. I have no document to show that I took possession of the suit property. I have got no money lending license, not a fact that suit has been falsely instituted, not a fact that the trespasser wrongful occupier, not a fact that I am legally bound to pay money to the defendant number 3, not a fact that the draft conveyance was not prepared as per agreement deed, not a fact. I am skipping over next page, Lordship,
Yes.
cross-examination. I made cash payment to 50,000. Sukumar Datta, out of which 40,000 towards loan and 10,000 towards advance. On 16/10/95, I gave cash payment of rupees 50,000 to Sukumar Datta as advance. Therefore, he is taking 50,000 towards advance. I have got bank account. I am an income tax payee. I do not recollect whether I made payment to Sukumar Datta after withdrawal the same from the bank. I do not maintain account in respect of the income and expenditure daily. I do not recollect wherefrom I collected the aforesaid money which was given to Sukumar Datta. I am not aware whether a sum of rupees 20,000 cannot be paid by cash. At the relevant point of time, I was not he's keeping or something, or I am an income tax payee, over he said. Now again he's saying, at the relevant might be at the relevant point of might be. I am keeping.
Explainable.
Yes,
Explainable.
explainable. Without going through the document, I cannot say the year when I started to pay income tax. I do not file the copy of the income tax return. Not a fact that I did not pay any amount to Sukumar. I was
Mr. Rai, before going over to the next page, let us come back to the first paragraph of this page. He says that I made cash payment of 50 to Sukumar on 12/6/95,
Yes.
out of which 40/10. And 16th of October 95, I made cash payment of 50,000. What is his in the plaint case?
Plain case, my lord.
Does he say that he made these two payments?
According to plain case, my lord.
Hmm.
Just I should.
Yes. Because if we, before going on further, we just want to.
কত page?
That was page.
Page 34. My
Your
lord,
page
have to search for
won't
it.
tally here.
Yes. In my case,
Yes. In yours 35 or 25.
yes, 25.
Please see the next page whether that is 26. And that 25
it is
continues with 36 and 37.
not only that.
Then we don't know how the rest of the pages tally then. Something must have.
Probably may
No,
not.
the last few pages are the last pages are telling.
Last
Anyway, let us not go into that. Because the last page is telling what the first few pages are.
97 is the last page.
Anyway, but paragraph 7 of this that amendment, they say something. Para 5, para 7. Is para 5.
Para 5.
A. No, that is the terms of the agreement. Sum of rupees 50,000 on 16th of October. And in paragraph 5, the beginning, he says on 16/10/95.
Even the agreement, my lord. Agreement, lordship, kindly see, clause says, paid on 16th on signing the agreement as earnest money, 50,000.
Yes. Yes.
Entire 50,000, he is saying, what? Factsiment 10,000?
1040.
1040.
6. Yeah, 12.
The 16th of October. How does 12/6/95 come in? Because at page 84 in their cross-examination.
Paragraph 4. Paragraph
Achha.
4 of the plaint. That is explained.
Put this 10,000. Thank you. So both the 50,000s are mentioned at least.
At least mentioned.
Very well. Well, let us continue. Sorry for disturbing. Page 84, the last few lines.
Page 84.
You are grilling the witness on income
Yes,
tax
yes.
from there.
Yes. 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 Taxpayer part is gone. I was appointed advocate on behalf of defendant number 2. This particular defendant number 2 is one of the son of Sukumar Datta. Sukumar Datta left my client as daughter.
Yes.
Wife, defendant number 1, defendant number 2,
Son.
Sukumar Datta is son. Now facts remain, defendant number 2 is all along with my learned friend's client.
Obviously.
Obviously.
Yes.
I was appointed advocate on behalf of defendant number 2 in other cases. It is a fact that I appeared as an advocate in a proceeding under 144 such on behalf of Somnath Datta, who happens to be defendant number 2, against Sobita Datta, my client. Similarly, I appeared in another case on behalf of the Somnath Datta in a proceeding under Act 39 case of Atho, and the case is still pending. That case was filed in respect of the goods of Sukumar Datta. So, Sukumar, I also appeared as an advocate on behalf of defendant number 2 in title suit number against defendant number 1 and 3.
So do you hint that he is an interested witness?
Yes. Obviously. Title suit is filed against defendant number 1 and 3. 1 happens to be mother, 3 my client. And this particular Sukumar Datta engaged Mr. Chakraborty as an advocate, and all through he was. Similarly, I appeared in another case an advocate on behalf of Somnath Datta in case number such and such. I also appeared in another case on behalf of Somnath Datta.
Who is Somnath? Somnath is 2.
Somnath Datta, defendant number 2. Before the Honorable Court, Sitaram such and such.
Several other cases he appeared.
Milord, here, Milord, I on basis of record,
Yes.
admittedly, my lord has found is a quarrel between the family members. Might be it is the outcome. Fact remain, it is on record. I will be showing to you, Milord. This Sukumar Datta filed a written statement, actually supported their case of the plaintiff. This my client married to a Muslim person. That is the whole controversy. He stated, I will not say anything what is not in his written statement, that he left the home, wedding with a Muslim. That is the whole controversy.
That is stated in the written statement?
Yes, I would show. Just for a while. Even on page 48 to 36. Page 48, WS of Somnath Datta, paragraph. May I read, Milord?
No, let us just get it first. WS of Somnath, yes. 48.
My father, paragraph, before dealing with the plaint, I state the following facts. My father, Sukumar Datta, had to leave his paternal residence because of his eldest Sobita, it should be daughter, Milord, fled away with a Muslim boy and married him on conversion. These are the reasons, Milord. Very unfortunate thing.
Yes. Family disturbance is also
Yes.
stated. You are for Shobita.
I am for Sobita. Alias, now he has become alias. Shaba, something.
Very good.
Now, my lord, I tried to convince your lordship what was the nature of agreement, what was the cross-examination of PW1, how he support. Now the question is, no, I will not spend much time. Straight away come to the point of limitation. Court had no occasion to deal with. Court could have. Court had only did this. Court had referred everything, but court did not go into the other questions. But in dealing with the limitation, court has referred every documents. Now my point would be, number one, interpretation of the alleged agreement itself. I repeat my submission, my lord. If the agreement as is stands on is interpreted, 6 months is the ultimate date. And in that event, my lord, section 54 squarely applies. Article 54 rather, it squarely applies. Because the sentence cannot be segregated into it covers 6 months. Number 2, possession. My lord, I am grateful to my lord. My lord has helped all of us with the judgment.
For that, yes, because we would confront the parties with that because we would be dealing with that.
Yes. The judgment squarely says it is not no matter possession. Agreement will speak for itself. Though we are denying the possession because we have already got a decree of recovery of possession. If decree of recovery of possession when it is redundant, my submission by to decree of possession. That's why the very first day I wanted to convince your talkers that they have got no case. Why I say, Ms. Scott? Now facts remains there is a decree of recovery of possession. Can it be said that when a decree is passed, court is satisfied, it remains unchallenged whether they can take the point of possession?
Decree of possession in a separate suit.
A him should buy your counterclaim. Lordship
Oh, that
passed.
counterclaim was decreed.
Yes.
Whether they can say that?
Whether they can say they are in possession, they can implement. Decree is over them. Court has come to a finding that it was unauthorized. I am entitled to possession, recovery of possession. If that be the position, whether my submission would be by mutual knowledge, even their passive performance fails.
No, there is no separate appeal against that.
No, but the first Lordship Policy is the first order my lord has passed in this appeal.
Oh, yes, yes. That was right.
And what remains? If decree of recovery of possession is sustained by a court,
So the possession is not lawful
possession is lawful.
because it is under the guillotine of that.
Yes, and
decree.
no appeal preferred. And my lord, in the first order, my lord has held it. That you were to choose between the two. They have chosen the first one. If a decree of possession, recovery of possession is decreed by a court of law,
Yes, sir, we understand. The decree is standing. So, but how does that make a material difference in the main suit?
when should in
The possession, how is the possession relevant? In what context are you saying this?
their submission, my lord, the Sukumar made about them the possession. Their
But
submission.
that fact does not change. Subsequently, it has been rendered unlawful by a decree of court. That's a different.
Therefore, that position is no position. Now the
Subsequently rendered, but at that point, for the purpose of limitation, possession was given.
yes,
At that
according
point,
to
it was
them,
not under
according to them, possession was given. According to us, there is no position. Was
that
given.
possession being handed
That-
over possession at that point of time was not unlawful.
My lord, it was unlawful
Why do you say that?
because, my lord,
There was a decree.
there was in enforcement of a agreement, it was not given to them. Had it been a case in enforcement of an agreement, a possession was given, I could have understood. When the courts hold, it is not in passive performance, in enforcement of agreement, I could have understood. It is not in enforcement of agreement.
Why do you say it is not in enforcement of agreement?
No position. That is my case. No position was given. And Supreme Court also says, my lord, even if position is given someone case, we have to read by the contract itself. Somebody, some way, position is given that I would show to your lordship. Position is not the factor. Factor is interpretation of the agreement itself. My lord, I was also considering, supposing my lord passes any decree in their favor, can it be enforceable?
Why can it not be? Why do you say that?
After the decree of recovery of possession is in my favor?
No.
Not appealed against?
No, if it is not appealed against, suppose it is
Yes.
executed even, then also if they get this decree and have a deed, then they can either seek fresh recovery of possession or take out 144.
Therefore, below
144 is not strictly applicable
Spoiled is also troubling me very
you are,
much.
you are right, 144, because that decree is not set aside.
Yes,
So 144 does not apply. They have to file a fresh suit for recovery of possession. They can do that always.
can it be enforced? Now, supposing.
But the
we are-
difficulty will arise if you don't execute the decree. Then there's a decree for eviction. In the
Yes.
teeth of that, yes.
I was considering, my lord, because I find that's why, my lord, at the very first day I took up this point. My lord has relative, my lord passed order, Mr. Dhar, you have to choose between the two. My lord specifically said that 2 appeals has to be papered.
They can have one answer, Mr. Rai. If we grant a decree today in their favor,
Yes.
then in execution they can take out a section 47 saying that it is inexecutable, because if the entire title passes, there are some judgments, that if half the title passes or fraction passes, then decree does not become enforceable, does not become inexecutable. But then what will happen is, by virtue of this decree, you will have a deed will be registered in their favor, and they'll have entire possession. So the title vests in them. So that decree will be inexecutable. They made, but we are not here to supply avenues to the parties, either to you or to them, Mr. Dhar. That is provided they win. But here, Mr. Rai, even if the appeal is allowed, as far as our view is concerned, court did not adjudicate on the other issues. So in any event, even if limitation point you are satisfied with Mr. Dhar's argument, it has to go back. But then you have your decree for recovery of possession.
Yeah, that is that. But
You have that remains.
That
but
remains.
but this suit will be remanded there for decision on
my
the
lord,
other.
the second part, my lord,
They'll have to suffer the recovery,
my lord, if
the
your
eviction.
lordship considers, my lord, lordship will issue suit of probably 99 or old.
Suit of, don't say.
No. 99. 99. Now it is 2025. Our predicament, my
Only,
lord, my
only a
client,
quarter of a century.
my client, Mr. Chakraborty knows it. It is personal doubt. Has been in acute cancer patient. He's on deathbed. Almost. And so is also his husband. I
No
candidly
compromise is-
submit to your lordship.
No compromise is possible.
Yes, that I wanted to mean it. It should have been. It should be.
But
I beloved,
after the hearing is over, court
I
cannot.
if I offer it, because of that I have the beloved lordship can take me.
Even if you conclude
I
the
am-
arguments.
I am confident. I am
Even if you
that
conclude the
person,
arguments, will not pass
could,
judgment
after
for.
so many years, he could meet me in my residence, my lord.
If we are on egos, then Mr. Right will never be solved. You have to act as mediators, the good office of counsel or whatever.
It is possible.
I personally, I am a very bad mediator, so I
No,
would
no,
undertake
no,
that
no, no.
exercise. Justice Kumar may be a good mediator, I am not sure, but I am a very bad mediator.
Yes,
So
yes.
if I try to mediate, it will definitely fail. And therefore, if you can do it, we'll conclude arguments.
Yes.
Even before passing of judgment, if that is possible, we can't pass our judgment within a week, probably at least. We won't pass our judgment within a week at least. That we can assure you. So if it can be done, if it can't be done within a week, it cannot be done. It could not be done over 25 years.
Yes. 25 years.
It could not be done in 25
She
years.
is not in a position to work properly. I tell you, lordship. Once he could, after so many years, I was not finding him. Lot of chemos have undergone. And lordship kindly don't take it as I am trying to.
No, this is not a question of sentiment. But you are right. You are right.
99 suit. Now it is 25. Admittedly, position is with them. I'm not getting anything.
What can be a compromise formula? Tell us. Any compromise formula?
A payment to be made. A deed will be a simple thing.
They will make a payment.
They will make a payment. A deed will be executed. If on satisfaction of that, then a chapter is closed.
Mr. Thor, you can explore that. We'll conclude the hearing, but you can explore that. Ask your client. If some further money is given, they'll execute the deed and they'll not execute the
Yes.
recovery, the eviction decree. Obviously, they'll not.
Unless my learned friend's client is personally agreed with that, we cannot, we had all, my client has all the intention. That is why the second deed of conveyance was prepared at
We are not blaming anybody.
75,000.
We are not blaming anybody. Mr. Dhar, let us start with a blank slate from
The way of
From
this
today.
compromise is to be disclosed.
the
Way
quantum
must
of
be-
money which we will pay will have to be decided.
the entire money
can
has
give an
been
offer-
paid except 1633.
Then probably
Entire money has been paid.
any other argument, Mr. Rai, let us hear it. on
Yeah,
that.
yes.
I don't think that
No,
if
no,
they are ready to compromise, we are also ready to
I
compromise.
it should have
That
been
the terms of
because family
terms of
members also
compromise
take
must
admitted
be
position
disclosed.
from 97. According to them, they are keeping position. Wrong or right? But they are in position.
Probably in
We
this
are
case, it will not be possible. So let us
not-
conclude.
I-
If it is possible in the meantime, even we will take some time to pass judgment. So,
No.
You can-
First sentence, my lord. If they
and even if we pass a judgment, then also compromise can be effected because still the decree is not executed by you. If you execute the decree, then nothing remains. Any other anything else? Sir?
then, my lord, I was referring to on the
Yes.
question of possession.
Yes.
According to them, the judges finding also there that they are in possession since 1997 onwards. Lordship kindly see and admitted position naturally. কোথায় আছে বার করতো? না জাজমেন্টটা from June 1997, according to their case,
Where is that in the plaint?
in a 148, plaint is also there. Plaint is also there. Lordship kindly see their plaint, according to them.
Para 7.
There are 7. From June 1997, they are maintaining possession. Other two part after the judgment, in 2004, they have purchased it. But 2007, they are in possession. Now it is 2025. Substantial part they have already enjoyed.
The garage.
Garage.
Not substantial part, only the garage.
Garage. Garage.
The flat is
Garage is nowadays very important part, my lord. Guy,
not seen.
garage is a very important area.
It was 1995.
Anyway, my lord, 1997, they are and in decreeing the counterclaim, court has also filed it.
Yes.
And court has held this is wrongful possession.
Yes.
Therefore, my lord, not only one judgment, my lord has referred it.
That. Achha.
Paragraph, there is the judgment.
Yes.
B. Gopala,
Go on. Fatehji. 2015 8 SCC
Yes,
390. Yes.
paragraph 5, 6, 7. হ্যাঁ my lord দিয়েছিলেন
We had referred to this and
Yes.
you had answered this also.
It is already considered. In which it was extended till 1977 and the cause of action claim.
No, that is not a cause of action. Plain suit peaceful cause of action, huh?
Reported in
Position
2015 8 SCC.
positional.
Yes. Party's name was Fatehji and Company.
Yes.
Potassium company.
Gopala Gowda was one of the judges. B. Gopala Gowda was one of the judges.
Yes. paragraph 7. Here, my case is completely, I did not put in position. They are taking over possession is unauthorized, substantiated by decree of the court. Lordship kindly sees.
Hmm.
Therefore, my lord, here put in possession, and my case is, it was unauthorized.
In the recovery counterclaim, did they take a set up a defense of 53A?
Nothing. To distinguishable এখানে, here put in possession, here their possession is unauthorized by substantiated by court's order.
All
But
right.
my lord, kindly consider, my wisdom does not read, but still I have some doubt, very honestly submission, my lord. I have some doubt that after suffering a decree of recovery of possession, whether this particular truth itself is maintainable.
They can get back possession if they have a deed in their favor.
Lordship kindly sees.
They'll suffer the recovery of possession. That possession was unlawful.
Can it
Now,
be enforceable? Can it
No,
be
no,
enforceable?
Mr. Rai, if they get a decree, we are taking the best in their favor. It's remanded, they get a, we have to proceed on that. It's remanded or not remanded, they get a decree of specific performance of a contract. You are directed to execute a deed in their favor.
Yes.
If you execute a deed in their favor, they become the owner of the property. Then your right of getting a possession, that decree, that right is subsumed by their ownership.
Supposing I do not
Do not do what?
execute the agreement. After the court's
Then
decree,
it
I
will
have
run
to
through
go.
the court.
Then can the court when the
Yes,
well I have
it will be executed. Executed through court, deed will be executed as in specific performance degrees. Through court, it will be executed. Court can
then
execute.
my decree will become redundant.
Your decree remains,
Remain.
but it is rendered inexecutable under section 47 in view of the subsequent subsumation of your lesser right in their greater right of ownership.
So long my decree,
There are the line of judgment, Mr. Rai, you must know. Eviction suit was filed during pendency or subsequent to the decree even. Either a portion was purchased by the tenant or the judgment debtor or the entire portion. There are several judgments. If it's partially done, then still you retain the right to execute your eviction decree. Because, and there are another line of judgment, they become a co-owner. So you cannot execute that decree. They have a remedy. Don't ask us to elaborate further. We won't find those judgments for him. Mr. Dhar has to find. But provided he wins, ultimately.
another judgment, my lord, they have
Yes.
referred expression date, article used in article 54, 2009.
Yes, they have referred but given only the first page of the judgment. Mr. Dhar is very miserly. Extremely, he's an extreme miser. His son is very liberal. I know his son. From our school, naturally liberal. But his father is very, very miser. Just imagine the first page is given only to
No,
both the
no,
judges.
Handed over it. I have not handed over it.
Oh,
I can-
you have not even handed over.
No, what do I not?
No, this was not the court's citation. Oh, we took out then. Then we asked our PA, he took out. Worse than that then. You
No,
didn't give a Xerox copy at all. No Xerox copy. No
No,
photocopy.
that I have handed over. Complete copy. That 2015 8 SCC.
16, 15. The one which
16, 15 only I have
15-8 we gave you
Yeah.
that judgment.
the journals from the library, judges library was placed. I have
Wow.
handed over the slip to the
And you are expecting that he will agree to that compromise.
My lord, this book is for my own library, and there is no
Therefore, that is sacrosanct.
supplementary copies are not available to any of the libraries. If I send it for photocopy, it will be loosened. But the libraries copies are already
Don't you understand your case may be loosened if you don't look into the document?
He is
Your
maintaining
lordship.
for his, for
No,
his.
no,
I
you-
give it to you.
SSC online is given at public money to us.
Yes.
So it's very easy for us to look into. We'll take out
Maintaining
photocopy.
for-
And we are given a scanner also.
I shall hand over.
We'll buy with your money and Mr. Rai's money. That's public money. We are given SSC online as well as printers. So no
But
difficulty.
it is the concurrent judgment.
Actually, we are now developed with the assistance of our junior daughters already.
They are very good.
Now, she happens
good.
to be my junior also daughter.
Mr. Rai, actually, after the last fiasco, I mean, it was, I went too far probably. But after that, looking at her expression, I understood. And the moment I understood, I stopped. The moment I understood, looking at her expression, I immediately understood and it clicked in my mind, and then immediately I stopped. So we understand that.
I am handing over the judgment from the AIR.
We'll take it.
The original judgment is same.
Which
There's no
one?
difference between
This is AIR.
AIR from the AIR.
AIR difficulties because you
The
cited.
paragraph may not tell you with
Paragraphs
the
will not tell you.
that time.
We'll find out. No difficulty. Yes, Mr. Rai, finish the arguments.
Only first limitation.
Oh, this judgment, yes.
Expression date fixed for the performance is crystallized notion. Article 54.
Yes.
In my case, Miller, date has been specifically given, execution and 6 months. Definite date is fixed, prime of 6 months was given. Therefore, Miller, by submission, Article 54 covers.
Very, very. That is all, Mr. Yes, please take your seat. Mr. Dhar, any reply?
Fine. In respect to the performance, my lord, I'm placing before your lordship the performance that how the entire money has been paid, entire money of or 1 lakh out of 1,05,000.
Hmm.
The receipt in page 191. Exhibit 1.
Yes.
That is the receipt for 10,000 signed by Sukumar Datta on 12/6/1995. Thereafter, for 40,000, Exhibit 2.
Yes.
40,000 on 12/6/95.
$10,000 on account of advance, 40,000 as loan.
Yes. But no, my lord.
That's written in your receipt.
This money receipt was issued on 12/6/1995. On the date when the
It's
agreement.
written in the receipt itself. 40,000 received rupees 40,000 from Prashanto as loan for 6 months. And the previous receipt, it's written there only
Yes.
on account of advance.
But
So we are reading from your
this
receipt.
receipt was issued on 12/6/1995.
Yes. Both the receipts.
Both the receipts.
Subsequent payment of 50,000 not substantiated.
Substantiated. As it has been.
Not in the memo of agreement. No memo of consideration in the agreement. No receipt.
There was no separate memo.
Nothing. Admitted that there was it was not in no separate memo.
My lord, kindly
There's no
come
receipt
to
also.
page 196.
196. The agreement again. 196 we have by heart now.
The agreement.
Yes.
No,
We have memorized it. You can ask us. About you.
here it has been written that has already paid. Only is paid. Only is paid this day. Of
Yes.
October.
It's written in the agreement.
16th October 2019.
Right.
On signing this agreement. As
Agreement
earnest money-
itself mentions, yes.
as earnest money in part payments. It itself is a receipt.
Very well.
So no separate receipt is required.
We'll record that.
Moreover, your lordship, kindly come to page 280. It has been admitted by the original owner.
280. 280.
I am talking about the 280 of the paper book. This is the main memo of the deed of conveyance executed by defendant number 1 and 2, the widow and son of the original owner. Exhibit H.
Yes. All right.
Exhibit 8 by the DW1, the defendant number 2, the son.
Yes.
They have agreed 10,000, 40,000 and 50,000 has already paid.
Mhm.
And in addition, 3,333.
This sale deed was in respect of apportion. So you have this
Two-third.
suit is for two-third.
They are say 2/3.
Oh, that. Yes.
During the pendency of the suit in
So they have
2004,
admitted, those two people have admitted.
1 and 2 agreed to execute. All along they agreed. Only I am not talking.
Being able to.
Don't believe in anybody's personal life to point out in anybody's personal life.
In 2004,
Both of them agreed except the defendant number 3.
after
It
the
is admitted that she was out of home. She had no connection with the family, and naturally he had no scope to learn about the entire incident, what his father did
All right.
during his lifetime.
Good.
This has been agreed. My lord, if the original owner signed that it has been paid on signing of this agreement as the part earnest money, then this 50% is also admitted. No further memorandum is not required in the agreement for sale unregistered. It is not required.
Very good.
My lord, to take support of the judgment which I have placed before your lordship on the last occasion,
Yes.
I am again coming in the exhibit 3 at page 194.
Yes.
Registration was not required in the year 97. I'm sorry, my lord, in the year 95. The agreement in the year 95. It was not required. The seller include their heir, executors, successors, etc., etc. So his heirs are also bound to regard this particular agreement for sale. None of the heirs had no option to make their own choice. But here the defendant number 3, the daughter disagreed. So challenge was differently regarding existence of that agreement, particular agreement. Thereafter, my lord, I am coming to
Yes.
the terms 1 at page 196.
Yes.
This entire reading, I can read again,
Don't.
but the reading says
We
it is
remember.
to be made over
Yes.
the space of the ground floor, on the ground floor of the building, be made over to the purchaser after completion of the construction. There is a pause within 6 months from the date of agreement for their use and occupation. Inhabitable,
There should be a space.
inhabitable is added.
Space in between.
The gap
Inhabitable.
missed is inhabitable condition. The premises number has been given. Now, your lordship, the possession has, there is no indication that it is to be executed. Conveyance deed has been executed within 6 months from the date of agreement for sale. That has made confused to the learned
But
trial.
that you argued on the first day. Do you remember that?
There
We
is
have looked at it.
confused the learned. There was no indication of execution. The execution of the decree I'm sorry, my lord. The execution of the deed of conveyance, it has been categorically mentioned in the next page. Within 1 month
Mr.
from the-
Thought you agreed in extenso, we remember that.
from
So we'll close
from
our
the
argument.
date of possession.
Don't repeat your argument. Yes.
And here, while the possession has been given,
Yeah.
within 1 month, in June 1997, the possession has been given. And on 21st July, the draft of deed of conveyance made ready. Unfortunately, on 25th July, he passed away. So this performance by between the original owner and the plaintiff was absolutely all right. There was no difficulties.
We'll
There
clo-
was no gap.
Close arguments. Yes. Hearing is hearing is concluded. Push up. The appeal is reserved for judgment. Thank you very much. এটা একটু staple করে দেবেন. We'll
The
take up the next
learned had concentrated only on the limitation,
limitation.
not on the merit.
Absolutely. So we'll come back and take up the next matter. This matter is over. কবেকার শুক্রবার? আচ্ছা, good.
Item number 3.
Well, Lord, we beg to appear on the
Yes, Mr. Mukherjee. Yes,
had the chance of submitting before your lordship last Thursday.
yes.
You're getting a chance again. Now, my lord, I was otherwise submitting before your lordship the evidence of one Manoj Kumar Jaiswal.
Mr. Mukherjee, at the risk of, being rude, we are requesting you, if you can, as much as possible, please be precise.
Yes.
Because of the time constraints. Because you are the senior people, you can if you want. So we'd request you, don't compromise your client's interest, but as precise as
So
possible.
I have got it marked, therefore it will be
Easier
short.
for us. Right.
Your lordship will kindly come to the second volume.
Yes.
I was referring to page 272. In fact, I'll start from page 272. This is the evidence of Manoj Kumar Jaiswal
Yes.
in respect of money suit number 42 of 2011, which was otherwise having a same contention in respect of this matter and that matter. This is not the matter which we are arguing for, but this has been marked as exhibit. Now, let kindly allow me to come to page 272. I'll got the marked portion. I'll read only the marked portion.
Thank you very much. Yes.
Second paragraph of the first page. The last sentence of this page, the receipt copy, the receipt copy of the said notice addressed to the defendant, and the same is marked as exhibit 12. Lordship, kindly remember this. Then kindly come to the next page. These are the Xerox copies of purchase register of the defendant for the assessment year 2005, 2006, 2006, 2007, and 2007, 2008, containing 11 pages. We got this copy of the same marked exhibit 13 collectively. From where did they get this copy? Number cross-examination starts from the same date itself. I'm not reading the first line. Kindly come to page 274.
Yes.
Now, the trial court marked these documents as exhibit. Kindly see what are those documents. Exhibit 12 is handed over to the witness. This exhibit 12 is a photocopy. If photocopies are marked exhibit like this, it's very difficult. Then exhibit 13 collectively is also a photocopy. Then our next paragraph, it is a fact that I am not in a position to produce the original document of exhibit 12 and exhibit 13. Not a fact that I am not aware of the contents of exhibit 12 and 13. It's a fact that exhibit 12 and 13 are not prepared by me. Not a fact that I did have certified copy of exhibit 12 and 13. It is a fact that I did not obtain certified copy of the same. In exhibit 12 and 13, there is no mark of the Honorable High Court. No, not a fact that it is not a correct statement to say that I got the document from the Honorable High Court. Now, how is it possible? If something fishy has not happened, how is it possible? I say this because I was mentioning about Mr. Taraknath Mitra on the earlier occasion. If this document has not been prepared by him, it is not a certified copy. It is not otherwise handed over to them from the court, or the other side is handed over to them. How could they get hold of this copy? Except for Taraknath Mitra handing over to them, if at all. No one else could have handed over to them this particular document. Now, kindly come after the 2 lines after that. So far as my knowledge goes, the order in exhibit 12 and 13 was passed in the month of June 2009. It's a fact that I am neither the sole proprietor of HP Trading Corporation nor any partner of the same. As being son, I am connected with HP Trading Corporation, where my father is the sole proprietor. This is neither here nor there. But still, this is something they're trying to espouse the cause of the other matter by this evidence. Next, I'll come to the evidence of Prem Narayan Jaiswal at page 275.
Yes.
He is the sole proprietor.
Hmm.
What does he say? Well, his evidence is not so much important. I'd rather skip his evidence and come over to his cross-examination.
Hmm.
74. But my friend is saying that we should read paragraph at page 274. I read it.
Yes.
Exhibit 4 is handed over, last paragraph. Exhibit
14,
4
yes.
is handed over, 14 is handed over to the witness. I do not have any document in connection with the VAT return for the financial year 2005, 22, 2008 in respect of Metco Group of Engineers Private Limited and Exomet and Allied Products Private Limited. We maintain the copy of value added tax in our office. Where is that document? That document is conspicuously missing. We have not filed any copy regarding VAT. Categorical admission. Not a fact that the document regarding VAT is a blue colored document. Not a fact that I do not have any idea regarding Exhibit 12 and Exhibit 13 collectively.
And he was also not recalled to produce this VAT document.
No.
My lord, these are all evidences relating to other suits,
Yes.
not in this suit.
But this was marked as an exhibit in this suit. This evidence,
No, it has been marked exhibit in those suits.
no, this evidence of MS.
Evidence was taken into this suit on his application.
This
Order
evidence
13
is
rule
marked
10,
as
order
exhibit.
13 rule 10 probably.
My lord.
The record was brought from that suit to this suit.
No,
Yes,
no, no.
it is
All the
certified copy
certified
we filed.
copies have been filed. I don't know how these are relevant, my lord. I fail to understand.
Achha.
Why should I
Because-
otherwise tell you
just-
why it is
just-
relevant?
I'm just giving the glimpse. I'm not going against.
No, no, Mr. Dev, when your
No,
turn
only
comes.
the 42 evidence.
When
will
your
be
turn
required
comes,
for-
otherwise this will not be
for
over.
the cause of action in that 42.
Let Mr. Mukherjee complete, you will have your
Yes,
turn.
yes,
Yes.
Now,
Hmm.
we have not filed any copy regarding VAT, not a fact that the document regarding VAT is a blue colored document, not a fact that you don't have any idea regarding Exhibit 12 and 13 collectively. This is Manoj Jaiswal's evidence. Manoj Jaiswal is a PW1 in this case in appeal before your lordship. My lord kindly comes then to page.
This was a money suit in what context?
Same type, same thing.
Regarding different transactions. Other transactions.
Different company or different firm.
Oh. But then, Mr. Mukherjee, why is this relevant? He's right.
Relevancy is this, that the same person is coming before the court and saying something else.
No confrontation.
No, but it's in connection with a different set of transactions.
No, set of why we got it exhibited. There is a reason
Yes,
behind it.
why
The
exactly?
reason is that your lordship will be pleased to find that so many things they have admitted in other cases which they are trying to deny in this particular case.
But there also they did not produce the VAT.
Nowhere they are produced. In none of the cases they have produced. Women's certificate, I told the other day, women's certificate in respect of this matter not produced. Consignment note not produced.
So non-production in a
Balance sheet
different
not
suit,
produced.
does it have a, is it a relevant fact under the Evidence Act?
Vipon Manal.
Is it a relevant fact under the Evidence Act for deciding this suit?
Why not?
Non-production in a different suit.
No, I'm not saying of this in the suit which was
Other
pending.
suit?
Yes, in the appeal in which we are otherwise arguing for. In the appeal which we are otherwise arguing for,
Yes.
there they have not produced the women's certificate.
No, that is a different thing. But
No.
why are these evidences relevant?
This evidence because it's
different suit,
pari
different
materia with
transactions.
the actual situation. The transactions according to them are the same.
Apparently was the canvas for this court below. Thereafter High Court passed the order. You can rely upon the evidence. Thereafter we are relying upon. Because modus
Very
operandi to prove the modus operandi.
Then my lord kindly comes to page 279.
What the actual fact.
279, yes.
Let further cross-examination of PW1 resumed on such and such day. The plaintiff firm was a registered partnership firm. I have not filed any document to show that Ridha Narayan Jaiswal and myself were partners of the plaintiff firm. I will file partnership deed of resolution and deed of resolution memorandum register of firms today. Another partner, Hriday Narayan Jaiswal, has died on such and such date. Question. Will it appear from the partnership deed we have filed today that this was a registered partnership firm? Answer, it will not appear from this document that this firm was a registered partnership firm. But the reason behind our asking this question is that in none of the cases, they've been able to show any document to satisfy the court's consent that the partnership firm is registered. Even in this case, which we are arguing for before your lordship, they have not been able to prove it. This is our contention. I will show where I will be arguing order 41 rule 27 that what the documents they have placed before your lordship is otherwise totally scared from the actual issue. Next paragraph. It would be correct to say that the partnership firm was registered long after 30 years from the date of partnership deed. The partnership firm was dissolved on such and such in terms of the deed of dissolution filed today. I have given notice to the register of firms about such dissolution of partnership, and this is not so much important. 3-4 lines after that, Taraknath Mitra was one of the directors of the defendant company. Lordship has got it?
That's an admitted position.
Yes. I cannot say whether Taraknath Mitra has any relation with the defendant company now. Taraknath Mitra used to sign the checks for the defendant company along with another director. I have no factory, but I have a shop of my own. I purchase goods from outside, sell it. I am an order supplier. I used to collect orders from my brother and my brother used to collect orders. Now, my lord, thereafter, your lordship comes to page.
Here also firm registration acknowledgement receipt was produced.
Yes.
And marked as Exhibit 10.
Then, my lord, we come to page 325. This is the evidence of Manoj Kumar Jaiswal in money suit number 44 of 2011.
This is another money suit.
Another money. 4 suits are there. Cross-examination, page 327. This is trade center. The matter which is going on before your lordship is also trade center. I am the partner of Messrs. Trade Center. I did not produce any document to show that I am a partner of this firm. This firm is engaged in the business of commission agent and general order suppliers. It is a fact that the original claims of the plaintiff firm is against the Betco Group of Engineers Private Limited. It is a claim in between March 2007 to August 2007. We did not file the quality report for the materials supplied. There is no written agreement with our firm and the defendant company. All orders were taken on verbal basis only. I have not filed any document to show that I am one of the partners of the plaintiff firm. Next page. I have disclosed my plaint as to who other are the partners of the plaintiff firm, partnership firm. Factory of the defendant company is situated in such and such place. I have no document to show that the defendant company manufactures such and such things. Defendant company used to place orders to us all verbally. We have no papers to produce that defendant company has placed orders for such and such things. The next 4 or 5 lines after that, my lord, I shall produce the deed of partnership if so required. This is the registered partnership firm. There were 2 chalans and 2 bills for rupees such and such. Defendant company used to collect the materials by their own transport from our firm. We are iron and steel general order suppliers. This is open, my lord. We come to the next page, my lord.
Based on Hura, I have filed the challan. The company is a registered company, admittedly. How can they take overall order?
Well, if you come, my friend is saying we should go back to page 328. Practically from the middle. I have filed challan in response of my statement wherein paragraph 4 of the plaint and the plaintiff raised bills upon the defendant company. Page 328.
320.
8. Defendant company used to collect materials for the own transport from our farm. We are iron and steel general order suppliers.
These are not relevant.
These are not so much relevant.
No, no.
Then, my lord, we come to the evidence.
When Mr. Banerjee suggests you to go through it, the presumption is you should avoid that page. He's too meticulous.
No, he is definitely meticulous.
Two is the keyword.
Another thing, my lord, one
Yes.
page is missing. I don't know
Oh.
whether it's there in your lordship's brief.
Yes.
I was just marking, I saw one page is missing. Page 3 in an evidence.
Page 3, page 327 is page 3.
No, I have noted that page 3 is missing. I just submit to your lordship. 1 minute.
Yes, yes.
I declare. I'm sorry, my lord, I'm taking time.
No, no, it's
Yes, evidence.
3 minutes, na 40 words.
Ajay Jaiswal, 315. It starts from page 315. I'll come straight away to the cross-examination, my lord, page 317. The first line of 317, these are the Xerox copies of VAT returns for the financial year 2006-2008 of measures Metco Group Engineers Private Limited. On earlier occasion, my lord,
yes, we are there.
on the earlier occasion, this document was marked X for identification. I am one of the partners of the plaintiff firm. This document containing 7 pages is marked as Exhibit 10 collectively. Now, how is these documents being marked? This is also a question which is coming up. Photocopy of VAT returns for the financial year such and such a Metco Group, which was earlier marked X for identification. Now it gets marked. Why it is getting marked?
Those money suits are still pending. These money suits?
Yes, this is pending.
All pending.
This is pending. Exhibit the cross-examination.
So that you can argue that in that money suit.
Yes, of course. Exhibit 10 is handed over to the witness. There is no signature on the first 5 pages of the document, but there is a stamp on the first page of this document, and there are signatures on the last 2 pages. This document is not prepared in my office. I do not have any personal knowledge in respect or in connection with the particulars so mentioned in this document. In this document, there is a signature of the director, namely Taroknath Mitra.
Mr. Mukherjee, what is the point of placing? I mean, what is the why are you placing these evidences in other suits? What is your point? I mean, what do you want to impress upon?
Point is, these matters are all same, practically same. The same point, same statement are there in the examination chief. I'm not reading it. Same statements are there in all the matters.
So how does that? How is it relevant?
Malad, I respectfully submit before Lordship that here is a situation where the entire thing which has been colluded with Taroknath Mitra is coming up slowly and steadily.
So you say collusion with Taroknath Mitra is the pivot of your...
Yes, yes. Or else how could they have these documents? Malad kindly considers without Taroknath Mitra being otherwise amply submitting the documents to them, how could they otherwise have these documents with them?
But that will be conjecture, wouldn't it?
No, it won't be conjecture, my lord.
They could have had it from Subroto Datta.
No. It can't be.
I think, just a minute. I'm sorry. I'm very sorry, my lord. Well, in the company code, there is a subpoena to the taxing authorities for production of the records which they have filed. Those records are produced before the company court. And there is an order of Justice Maharaj Sinha that has already been shown to your lordship. to supply the copies of the document to both the parties. Copies are supplied. Thereafter, those documents are dealt with in Exhibit 2, that is the judgment of company court. Those the notice to produce document was given.
Yes, yes, you said that.
They did not produce. Then those are given. Under 65, my lord.
This is under the, these evidences have been recorded, taken on record under the orders of the High Court. I do not have any personal knowledge in respect or in connection with the particulars so mentioned in this document. In this document, there is a signature of the director named Taraknath Mitra. Lordship has got it. We obtained this document from the court, but there is no stamp or signature of any court. Next page, my lord. I have filed documents in court to prove that I am partner of Messrs. Trade Center. This Trade Center is the same Trade Center here. Even if such documents is not found in the case record, still I remain as a partner of the said company. I became partner in the year 1984. Lordship has got it. I'll show from the document which they have produced now that they have joined the partnership in 2009. We have partnership deed, but I cannot remember whether or not I have filed the same. The firm was constituted in the year 1984 itself. Myself and Manoj Kumar Jaiswal were partners initially and will still remain the same. I studied up to class such and such. I am not well conversed in English. There was no contract between ourselves and the defendant regarding supply of materials to them. The defendant company used to send the representative and we used to deliver the goods to him, which were carried away in their own vehicle. We are into trading business and have no workshop. We used to sell the materials for profit. There was no fixed percentage of profit. Sometimes the orders were placed by us, with us by different company over telephone, and sometimes orders were placed in writing. That means there must be some order is writing at least. Something should be produced before the court, my lord. They used to send the specifications as well as the volume of the goods, which were meant to be supplied to them. I am to search for the written orders which were placed with us by the defendant.
But apart from your allegation that there was a collusion with Taraknath Mitra for which they obtained, that is how which they obtained the copies. Otherwise, this evidence is entirely irrelevant for the present purpose. Whether they could produce written orders in the other money suits,
no, my lord,
different
in
transactions.
This matter, this is also trade center. Our matter is also
Trade center may be common, but these are different transactions. If they could not produce documents regarding that,
I'm not disputing they are different transactions.
You can argue that in that suit, but it's not at all relevant for the present purpose.
But my lord, I respectfully submit that in this case, what we intended to show before the court is the same are pari materia with the other. They are trying to show that they are absolutely sadhus and with a dubki in Kumbh Mela, and then they have come and they are saying something.
Many sadhus are being exposed in the Kumbh Mela by YouTube.
Sadhu, not Naga Sadhu.
That's a different ball game altogether. So, Mr. Mukherjee, these are not. These could be at best arguments in that.
Yes,
they did not.
But the thing
their
is,
stand is consistent in all.
Their stand is consistent that we are not going to produce any document and we should get the decree.
But you can rely on only
Then come back to the partnership situation. Let us stop the evidence which is not here and come back to the partnership situation. I could have shown you from the evidence. Well, of course, your lordship is
those
would be evident for the other one.
Right, because of those would be German in the other suits. Maybe the other suits would fail for that.
Come to the documents first. Let us place the documents one by one.
Yes,
they have placed few documents regarding. This is Exhibit 4 probably. 14 numbers of bills and chalans.
Which page?
Page 192 of the second volume.
Yes.
This is bill number such and such. Lordship has got it?
Yes.
And amount is 61,691. Lordship, rounds and VAT 4% has been added. Who has received this bill? Who have received this? This is 30th of January 2006. Who has received this bill? My lord, kindly comes to the next page. This is also bill number 148, TC 148 0506. This is 28th of January 2006.
Same argument, none received.
No one received.
All right.
Even the total is also not there. Then third, 194, some gentleman's signature is appearing to have received the bill written by hand on 28th of January 2006. That means this is
These were proved by them.
yes. This is challan number 1480506. Kindly come to the earlier one. Bill number 148.
Challan number is same as the previous.
Yes. Then here they want to say someone from Exomet had signed this.
Yes, the stamp is
20
there.
on 21st of January 2006, if I am not wrong. Now, if this is 21st of January 2006, then how could the challan be made on 28th of January 2006? Challan means the stock has gone. Earlier to the date he has received. Now, thereafter, there is a declaration. I am not on the declaration again. Kindly come to the next page, 196. This is again challan against 149 of 05. No, 195, no, declaration. Declaration of Trade Center.
For the VAT.
VAT or tab, I don't know.
For each transaction, declaration is necessary. That declaration.
Kindly see, this is dated 30th of January 2006. One stamp appears to have been signed by a gentleman, either 3rd of January or 30th of January. The signature appears to be different.
No, same is Ghosh. Same as the previous.
Whether it is Ghosh or not, or anything, I don't know, but some signature is definitely there.
All right. Maybe is Ghati or is Ghuri also.
Maybe. But here also, Ghosh is not available. Some other signature is available. Now, my friend is saying to show the declaration. Let us at least see the declaration of page 197.
For each transaction.
I'm not saying, I just show one. Why should it show everyone? They've prepared it in a very interesting manner. Kindly see, my lord. Place of dispatch they have given. Consignment rounds, quality, quantity. One can know what is that. Weight. 26601. No, 2600 kg. Value such and such. TC 149 such and such, such and such. This is a certificate stated to be issued by them. Whether we have received it or not, any statement, any signature. The next one also, same thing, bill is not signed by anyone. The challan is signed by one. Now this time it's a capital letter one, Ashish Das.
This could be received by anybody who was on the site.
Yes. No one, they never tried to bring in Ashish Das before the court to prove these documents or raise Ghosh. Now kindly come to page. I was showing my lord page 199. Now if your lordship kindly turns to page 205. Must be the same person.
Now not in block letters.
Not in block letters. This way things, then again, at page 210, one Raj Kumar something, 15/5/2006. These bills, challans are done by hand. and signed by Ajay Agarwal.
Why they did not have produced.
Yes.
I was submitting before your lordship. My friend was also saying that everywhere the VAT declaration has to be given. Kindly see, I'll show only one.
Those are there after each of the pages.
Beg your pardon? Yes.
Those are there after
Yes.
each of
Their VAT number is, which is given in every tax invoice or something, what they're calling it, chalans, bill. VAT number is given. Where is that VAT declaration? They've taken VAT. My lord, I'll respectfully submit, after they've got it purchased from some other outside source, they've paid VAT. Where is such declaration? No document of purchase is coming before the court. No consignment note, no payment.
That number is of the consignee.
Party's VAT number is given here.
No, registration certificate is that number.
That's
Consignee.
very
that
good.
number.
Very good. Whatever is there, we there. We
That number of the defendant.
buyer's VAT number.
Yes, consignee.
এই যে দেখুন এই যে বলছি শুধু বলছি
VAT number is there, my lord. In any bill, your lordship sees any challan.
Buyer's VAT number.
Last printed 1935048509.
There is a buyer's VAT number. Buyer.
The last one printed
Acha.
at the bottom.
Oh. All right.
That number.
Yes, right.
Sales tax, CST, and VAT.
Yes.
they sell it to me they have to purchase it from someone
Well, now if they have purchased it from somebody, they have paid VAT.
Mm-hmm.
Where is that document? They have purchased without any document from someone.
That is not necessary. They have given to you, that is only necessary. From where they have purchased,
Now, if they want to, we say that if we didn't receive it, such things. This is the difficulty. We didn't receive these things.
they need not show where they purchased from or produce a VAT of that. Somewhere that would be too much.
No, why? Because these questions
They
came
only have
up.
to show that these were sent
Well,
to you and received.
these questions have come up. That is why I'm showing before the lordship. These questions have come up in the argument and in the evidence.
supply and delivery
But they have produced so many challans, receipts with your stamp.
supply and delivery can not
Whether it's our stamp or Taraknath Mitra's stamp, no one can say
The
anything.
stamp is also of Taraknath.
Yes, yes.
That was the suggested to Tarandan Mishra. He is witness.
delivery is to
He has
prove
not said so.
delivery to prove
He is witness.
যিনি আমাদের supply করছেন।
No, I respectfully submit these. I'll not go to other same situation. Page তুমি কোন পেজ বলছিল? মনোজ কোথায় গেল? কোন পেজ বলছিল?
Delivery টা sold and delivered
তারকনাথ মিত্র
Purchase
কোম্পানি থেকে
sold and-
চলে গেছে।
সোল ডেলিভারি
That
শুধুমাত্র
chapter
ডকুমেন্ট
that
কেন
one
করবো মোড়া সাবরন্তি দেওয়ার জন্য দেওয়া হয়েছে কোনো পারচেস করেছে
না,
We have
easy.
we have produced those evidences. We have produced those evidences to show the modus operandi of the plaintiff in the appellant here. Now kindly come to the other documents. This is the notice of 3rd of June 2008, page 228.
Yes.
This is written to Exhumate and Allied Products, our predecessor.
Hmm.
Dear sir, in accordance with your order placed for month of January 6 to March 2007, on different dates we have supplied such and such things. At Kantalia, Domjur, Nibra, Howrah, of which you have received all the aforesaid goods without raising any objection. Subject to our delivery, you have raised bills from a total sum of rupees such and such on diverse dates from time to time for the price of goods sold and delivered to you. In spite of receipt of all bills, you have paid only a sum of rupees such and such by an account pay check drawn on such and such, leaving a balance of such and such. The reasons both known to you, we are enclosing herewith with Xerox copy of challans and bills. Thereafter, despite several requests and reminders, you have failed and neglected to pay the said sum of rupees such and such, nor any portion thereof, and you were withholding the said amount wrongfully and most illegally in order to make unlawful gain. In view of the aforesaid facts, we do hereby demand of you to make payment of the said amount of rupees such and such together with 24% interest. Lordship has got it. This is the notice of demand. Now they have taken all together and made notice of demand. Page 230, Exhibit 6. This is notice to produce document dated 20th of November 2014. VAT return for the financial years 25-2006, as well as records of the input and output for the financial year 2005-2008 in respect of the Exomet and Allied Products Private Limited at 4 Ripon Street, and subsequently merged with the defendant company, that is Mega by Bridge Products, 45 Jhautala Road.
How did you answer this? You did not produce the documents.
No. Where do we find these documents?
No. They asked for the entire your VAT returns for the financial years mentioned there.
No. We didn't
Not only
produce
for
it.
them.
We didn't produce it. In fact, I'll show from the records which are there in this court that the said Manoj Jaiswal did not have the authority even to sign it. You see, the letter now has stated he is the partner of Trade Center. Simplicity of Manoj Jaiswal. I'll not argue much on this because it's a short point which has come to my mind. I wanted to refer it before your lordship. Then the next document which they are produces exhibit 7 copies of documents. This is what they have produced from the High Court when they received it from the Honorable High Court. Then kindly come to Exhibit 8. Exhibit 8 is page 249. Memorandum from the Register of Firms. I respectfully submit this is only at best a document taken by the Registrar of Firms, an acknowledgement. This is at best an acknowledgement. Date is given as 14th of May 2010. Now I respectfully submit it will be time for us to come to Order 41 Rule 27 before I go to other points. Lordship kindly takes up their application. This has been oh my God. Malad, the order for 41 Rule 27 application. Lordship has got.
Yes.
Well, admittedly, this application has been filed in the appellate court.
The memo, the picture. This was closed.
Which? Lordship has got this?
Yes.
Now, let kindly come to the second paragraph. Sorry, third paragraph. The learned trial judge, by her judgment dated May 18, 2022, and decree dated 21st of May 2022, has disposed of the money suit holding. The suit is not maintainable. And since the plaintiff appellant petitioner firm is an unregistered partnership firm, in spite of considering Exhibit 8 being the memorandum or registration number such and such issued by the Registration of Firms, West Bengal, which is the only and sole document issued by the Registration of Firms, West Bengal, all partnership firms after registration. The learned trial judge further held that all other issues pleonastic because of the simple fact the suit itself is not maintainable and is barred under Section 69, subsection 2 of the Partnership Act of 1932. The petitioner categorically states that the petitioner firm is registered under the Registrar of Firms, West Bengal, as required under Section 69, 1 and 2 of the Partnership Act 1932. Your petitioner categorically stated the exhibit E8 being the memorandum of registration number such and such issued by the registration of firms. West Bengal is the registration certificate under the provision of the Partnership Act 1932 of the plaintiff appellant petitioner firm, which is the only and sole document to prove the registration of firms apart from the said exhibit. No other document is issued by the registration of firms West Bengal. Till this time, we do not find why they could not produce it earlier before the court. Your petitioner further submits a learned trial judge has also failed to consider that the goods are sold and delivered by commercial transaction, and the said contract of sale, including the instant suit, are all covered by the Special Act, being the Sale of Goods Act 1930, which is absolutely independent, being self-explanatory, defined and segregated from the Indian Contract Act. Then in the said judgment dated May 18, 2022, the decree dated 21st of May 2022, being passed by the learned trial judge holding that the exhibit 8 of the said suit does not relate to registration of the plaintiff appellant petitioner firm. The plaintiff appellant petitioner applied before the registrar of firms West Bengal, praying for the details of the registration of the plaintiff firm in the books of the registrar of firms West Bengal. Copies of the form 8 of the plaintiff firm issued by the registrar of firms West Bengal, along with the GRIPS e-chalan, Industry, Commerce and Enterprise Department, Government of West Bengal, is the next P1. Now, may I kindly come to P1. Paperwork part exhibit.
এই তো আচ্ছা আপনাকে একটা কপি দিলে বলতে পারবেন এরকম তো আছে
না তোমার কাছে আছে।
So Mukherjee will have to rise early before recess because my learned brother has a bench, another bench.
Oh.
We'll continue after 2.
Well, if your lordship kindly allow me from 2 o'clock to go to some other court.
2 o'clock, but the continuity will be lost. This matter is going on for so long.
My
If
lord,
you have any other matter, if any other matter is called on, then you may.
no, it's fixed at 2 o'clock, my lord.
It's fixed at 2 o'clock. Oh. So then,
We come back on Monday then.
Hard in part, pushed up. For further hearing on February 24, 2025.
Item number 4.
I beg to appeal, my lord, for the plaintiff respondent.
Yes.
I'm the defendant applicant.
Yes.
But today we are determined to complete the submission because
Yes.
on 14th November, first time I make my submission, then 25th November. Thereafter, within this period, Lord, I did not get any chance to make my submission.
Right. Lucky that you got your chance on 14th November at least.
First, 14th November,
Because the appeal is of 2018. So at least on 20th November, you got a chance
yes,
in 2023
yes,
after
yes.
5 years.
Yes,
Yes, what is that?
Lord, the food for partition and for Lord the
Achha, what are the two applications pending?
no application is pending, Lord.
Can one and can nine?
Occasion, my
Can
lord, I
nine?
disposed of one application with respect to, my lord, substitution.
That was can 10, but can 1 and 9 are still pending. You have also forgotten what has happened. Can 9 is probably, oh, 9 is for expeditious hearing of the appeal. And what about can 1?
Can one, Lord, that was for stay.
injunction.
That was never granted.
Yes, order was passed.
Identity order.
Yes.
So we will dispose of the applications along with the application. Partition suit, final degree.
Preliminary degree.
Yes, you are the defendant.
I am the defendant. Lord, defendant number 1 to 6. Not only the partition with Lord the another relief that suit for decree for declaration that the previous deed of partition is void deed and not binding upon them.
Why? For non-joiner of all the corners.
According to them.
And the court also.
And also court also, Lord. Lord, kindly, it would be convenient to Lord, place the case from page 94 of the first paper book.
Genealogy.
Genealogy.
Yes.
Lord, the Indumati Mullik and Narayan Chandra Rokhit, they jointly purchased the suit property on 13th November 1958. Then, Lord, according to plaintiff, Indumati had the two children, one Gopeshwar as the son, and Lolita is the daughter. Lord, the Gopeshwar died. We are the 6 representative heirs of the Gopeshwar. I am representing the heirs of the Gopeshwar. Next, Lord, according to plaintiff, Lolita married Jugal Kishore.
Yes.
Middle portion, Lord. Lolita married Jugal Kishore, and Lord, within their wedlock, 2 daughters were born. One is Kamala, another is Ostrukona. Lord, the Ostrukona has been made the defendant number 7. I am not representing the defendant number 7. Now, it is the further case of the plaintiff that a Kamala Rokhit.
No, 1 second. Lolita had 2 daughters, Kamala and Ostrukona.
Ostrukona.
Achha, very well, yes.
Ostrukona is the defendant number 7 here.
She has died.
So, Lord, it was further case of the plaintiff, Kamala married Narayan. Right hand side, Lord, top. But within their wedlock, one daughter was born, that is the Durga Chakraborty.
Very well.
Now, Lord, the suit has been filed by.
Suit was originally purchased by Indumati and Narayan.
Indumati and Narayan.
Achha, very well. Very well. Yes.
But the Kamala married Narayan. Within their wedlock, one
Durga.
daughter was born, that is Durga. Now, Lord, the Kamala is the first plaintiff and Durga is the second plaintiff.
Achha. You deny what? That the marriage you deny?
I denied 2 things. First, existence of Lolita.
Existence of Lolita?
Yes. Existence of Lolita. According to me, Indumati had the only son, Gopeshwar.
All right.
And my second defense is that suit property was partitioned in the year 1979 in between Gopeshwar and Narayan. when the suit property was partitioned, then Kamala was present
Present means?
at the execution. He participated in the execution. He saw the execution. He went to the registry office.
That is your case, or she admitted somewhere?
He admitted in cross examination. Therefore, the cause of action of the present suit arose within 3 years from the date of partition, that is in the year 1979.
So you deny the, the locus standi of Kamala and Durga at all?
Kamala, not Kamala. I denied the existence of Lolita.
No, you say, right, Lolita, yes.
Lolita.
Very well, very well.
So my
So
second.
the rest is admitted by you, that Narayan married Kamala, daughter Durga, these are admitted.
These are admitted.
Very well.
My second contention was that suit was barred by law of limitation because of the fact that in the year 1979 suit property was partitioned. Next, Lord, that is my third contention in the written statement. That was the Kamala. Kamala married first one, Lord, the Santosh.
Yes.
During subsistence of this previous marriage, Kamala again married Narayan. And Durga is the daughter of Kamala and Santosh. This was my contention in the WS written statement. Lord, kindly come to page 184 of the paper book.
Yes.
Issues. Lord, there were various issues were framed by the learned judge. Lord, the issue number 4, 8, 12, and 13. According to me, 4, 8, 12, and 13 are the important for the purpose of adjudication of the present appeal. 4, 8, 12, and 13. Lord, as it appears, the issue number 4 and 12 are more or less same. Now, Lord, I am addressing your Lordship on the point of the limitation first. Page 122.
1 or 2?
Sorry, Lord, the page 222.
Yes. Yes.
Lord, paragraph 4. Now, whether suit is barred by law of limitation is to be discussed. Point of limitation is a mixed question of fact and law and facts. To determine the same, the court is to first see what relief has been sought for. This is not a simpliciter suit for declaration that the impugned deed of partition is void. If it is a simple suit for declaration declaring the impugned partition deed is void, plaintiff is to come within 3 years from the date when the fact entitling the plaintiffs to have the deed cancelled first known to her. This is a suit for partition and declaration. Partition is the main relief and declaration is the constitutional relief. Because the impugned deed is void, having no binding effect upon the Kamala and Ostrukona, and the oral evidence of the PW1, that is Kamala Rokit, reveals her position in the suit property, and so the plaintiff need not to have the break for declaration that the partition deed is void, and without seeking such relief, she could directly claim the partition, and as such, partition is the main relief in the suit. Now, why the plaintiff has sought for declaration if it is not necessary?
The suit as framed is barred because declaration was the main relief. regarding void.
Yes, that is my case.
After holding void, you cannot say that partition is the main relief.
That is my argument before your lordship, Lord.
So unless it was held to be void,
Right,
partition does not come in.
Yes, and I will bloody place the judgment on that part also. Answer is that said partition did cast a cloud over the title of the plaintiff. Declaration creates no fresh right. It just removes the cloud cast upon the facts, which is all alone in existence. Furthermore, neither Kamala nor Osukona were made party to the impugned deed, and so they need not to have pay for its cancellation. Moreover, Article 59 of the Limitation Act is not applicable to void transaction, and so there is no question of holding the suit is barred by law of limitation. The point of limitation being mixed question of fact and law. The court should not read the oral evidence of the PW1, that is the Kamala, as to their knowledge about the impugned deed, as pointed out by the learned advocate for the defendant in isolation and in disregard to the position of the law as to ineffectiveness of the impugned deed. So this court is accepting the argument of the learned advocate of the is not accepting the argument of the learned advocate for the defendant in this behalf. Case law is cited such and such, and thus the court find and hold the suit is barred by law of limitation. Now let's kindly see the deposition of the PW1, page 216. Ten lines from the bottom, Miller. Learned advocate. The learned advocate for the defendant pointed out the following cross-examination of the PW1. PW1 Kamala Rocky stated that she had signed the partition deed at first week of April 1979 at the afternoon at Alipur. She, along with Gopeshwar Mollik and her husband Narayan Rocky, went to the concerned registry office. It took an hours to complete the registration proceeding. Gopeshwar Mollik bore expenses for the registration of the deed, and they returned from the registry office. Defendant have been possessing the half share of the suit property, and remaining half share belongs to Kamala. Drawing the attention of this court towards the above mentioned oral evidence, learned advocate for the defendant submitted the Kamala Rockit and other had the knowledge about the impugned deed. So, Lord, the paragraph page 222, here the learned judge has disposed of the point of limitation in favor of the plaintiff on the four counts. First, Lord, the learned judge has held the suit for declaration and for setting aside the void deed, Article 59 does not apply.
Yes.
First. Second is that for partition, there is a recurring cause of action, hence the suit is well within the period of limitation. Next, learned judge has held in the said suit, the partition is the main relief and the declaration is the consequent relief, and that is why the suit is within the period of limitation. Next, the observation of the learned judge is that on the point of limitation, that the deposition of the plaintiff number 1 regarding her knowledge as regards the execution of the impugned deed shall not be considered because the Article 59 of the Limitation Act will not apply. And next, Lord, learned judge has further held that for that declaration for setting aside of the deed was not necessary at all, but the plaintiff sought for such declaration since the said impugned deed of partition cast a cloud over the plaintiff's right. Now, Lord, on last occasion, my Lord can remember, I argued on last occasion, suit may not be regulated under Article 59 of the Limitation Act. But this is my argument on last occasion. The moment he has prayed for cancellation of the particular instrument by invoking the Section 31 of the Specific Relief Act, then the suit has to be regulated under Article 113 of the Limitation Act.
And you say the right to sue first accrued when the deed was executed.
My lord.
Kamala was a signatory.
Yes.
Specific relief factor din to.
Specific relief factor দুটো।
সেকেন্ডে চলে গেল ওটা না তো হিন্দি লোক তলারটা না 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 সেল সেল এগুলো না একদিন আপনি যদি একটু টাইম নিয়ে ইয়ে করে দেন
Specific relief factor।
একটু অ্যালফাবেটিক্যালি অ্যারেঞ্জ করে নিলে না এই প্রবলেমটা হবে একটা দিন একটু খালি থাকলে হ্যাঁ
I have a
নো নট রাইট নাও আপনারা একটুখানি না অ্যালফাবেটিক্যালি অ্যারেঞ্জ করে নেবেন এটা এতদিন করা উচিত ছিল
a written instrument is void or voidable
খুব পড়ে দিচ্ছি
and who has the reasonable apprehension that such instrument if left left outstanding may cause him the serious injury may sue to have it adjust void or voidable and the court may in its discretion so adjust it and order to be delivered up to up and cancelled. Subsection 2, if the instrument has been registered under the Indian Registration Act,
so even if it's void they have to seek for a declaration regarding that
yes,
and if they seek a declaration 113 the residuary provision
this is
comes.
my brought the argument. Lord, and my lord, this is my next submission. Lord, regarding the article 113, there says the cause of action when first accrues.
Yes.
There is a difference between the Article 59 and Article 113. Article 59 gives it on two stages the cause of action. First, when the incident happened and when the knowledge comes. But Article 113, Lord, when it happened first. So, Lord, it ought to have been filed within the period of limitation, that is the three years from the date of Lord, the execution of the deed. Lord, on last occasion, Lord, I had handed over one judgment. 2011 9 SCC. I have brought the again, but if it is available.
No, it's there.
But paragraph
24
24 to 30. হ্যাঁ বলো 126 paragraph
Yes.
24 to 30.
Yes.
Lord, paragraph 30, without Lord wasting my Lord's time, I am reading the paragraph 30. This is the important paragraph. While enacting Article 58 of Article 58 of 1963 Act, legislature has designedly made a departure from the language of Article 120 of 1908 Act. The word first has been used between the word sue and accrued. This would means that if the suit is based on multiple cause of action, the period of limitation will begin to run from the date when the right to sue first accrues. To put it differently, successive violation of the right will not give the right to fresh cause of action, fresh cause, and the suit will be liable to be dismissed if it is beyond the period of limitation, counted from the day when the right to sue first accrued. Lord, my learned friend will argue on this point that Exhibit 13, that is the one letter requesting me to have the partition. The cause of action is arising from there.
No, if partition is the main relief, then it
Fine.
arises dida indium.
Yes, yes.
But this argument depends on which is the main relief.
Main relief. Next, Lord, another judgment, Lord, 2006 5 SCC. That
Yes.
judgment, Lord, I also handed over.
Yes.
Lord, the paragraph 17 and 20. On previous occasion, my lord put a question to me. হ্যাঁ বলে দিচ্ছি 335 sorry 353. On previous occasion, my lord put a question to me whether the limitation this fact is relating to void deed or not. That is, you will answer paragraph 17 and 20. Once, however, a suit is filed for plaintiff for cancellation of the instrument it would be governed by Article 59. Even if Article 59 is not attracted, the residuary article would apply. Then, my lord, the paragraph 20, the plaintiff is in possession of the property. He may file a suit for declaration that the deed is not binding upon him. But if he is not in a position thereof, even under a void transaction, right by way of the adverse possession may be claimed. Thus, it is not correct to contend that provision of the Limitation Act would not apply at all in the event the transaction is held to be the void.
All right. Why did you cite this judgment? What is the ratio of the judgment otherwise?
But the ratio is that whether the limitation would apply in case of the void deed. That is the answer. That was what my lord put this question to me.
And para 16 is, please read para 15 and 16 also.
Section 31 of the Specific Relief Act thus referred to both void and voidable documents. It provides for discretion relief. When the document is valid, no question arises for cancellation. When document is void ab initio, a decree for setting aside the same would not be necessary, as the same is not honest in the eye of law, as it would be nullity. But I will place the next judgment where the Honorable Supreme Court has held the moment you have asked for cancellation.
Next sentence, next paragraph says, once, however, a suit is filed, it will be governed by here 59. But in your case, you say
Yes.
very well.
Next, Lord, it was the observation of the learned judge that the plaintiff ought not to have prayed for declaration, but he has prayed for declaration because there is a Lord, his right was clouded. Lord, I am placing the judgment 2008 15 SCC. This judgment.
Yes. Given on the last question.
No, Lord, perhaps this judgment.
Given.
Lord, I will place the two paragraph. Paragraph 62 first. হ্যাঁ দাদাকে একটা দিয়ে দাও তোমাকে সবাই পাঠিয়ে দিয়েছি গো হ্যাঁ paragraph not the 62 first. We may therefore notice the deed of partition exhibit D16 had been acted upon by the appellant and other sister. Lord, the same things happened here. The deed of partition was acted upon. I will place the relevant portion from the cross-examination of the PW1 and the PW5, where they have stated the shoot property was partitioned. It was bounded, butted and bounded by the boundary wall.
It was held to be void only because Lolita was not a party.
This is the only reason.
Did they prove, Fandijani proved to show Lolita was a daughter or whatever?
Lord, they proved the existence relation of the Lolita by producing exhibit 19. Exhibit 19, that is Lord, a document supplied by the chairman of the Ghatal municipality in reply to their application under section 6 of the Right to Information Act. There, Lord, I will also place exhibit 19. There is no contention regarding the relation between the Lolita and the Indumati. Not only that, Lord, my Lord knows the section 50 of the Evidence Act, only the resources where the relation is disputed, then the section 50 has to be invoked. Lord, I will also place before your lordships, Lord, the section 50, Lord, the PW3. PW3 was said to be the nearest person regarding the Lolita. And Lord, the deposition of the PW3, also everything regarding the first wife of the
We'll come to that.
Yes. Lord, the paragraph 62 and 67.
Yes.
paragraph 62, they acted
It
upon.
notices that acted upon.
Yes.
Yes.
Next paragraph, let kindly skip over paragraph 67. Applicability of the Article 59 would indisputably depends upon the question as to whether deed of partition was required to be set aside or not. In view of our findings above aforementioned, it was required to be set aside. It is not a case where the deed of partition by the reason of the purported wrong factual contention raised in the plaint leading to grant of the consent decree void ab initio. It was not. The effect of it would be that the same was required to be set aside. Say so and so judgment, it must therefore held that suit is barred by law of limitation.
But this does not help you because it says if here also it says that if it's void ab initio, then no suit need to be filed. By necessary implication, because it is still held here, it is not the case where the deed of partition by reason of purported wrong, whatever, leading to a consent decree was void ab initio. It was not. That's why 59 is applicable.
And Lord, here this judgment will help me paragraph 67 in such a way, because Lord, without setting aside, without seeking the cancellation of the partition deed, he cannot stay for the second relief, that is the partition relief. And that is why the cancellation of the partition deed was required to be sought for. And that was the main relief.
All right.
That is why Lord, the paragraph 67 I have placed.
And you also rely on section 31. In such a case, 31 ought to be in.
My lord. Now, Lord, kindly see the plaint first prayer.
Yes.
The page 24 of the paper book.
Yes. Yes, we've seen the first prayer.
Lord, let the decree be passed declaring that the impugned descheduled property partition deed of 1979 is void ab initio, which is conducted by the said Gopeshwar Mollik upon practicing fraud, practicing undue influence, fraud, coercion, and the misrepresentation on the predecessor interest of the plaintiff, namely Narayan Rokhit, and upon encroaching the respective share of the original plaintiff number 1 since deceased and the pro forma defendant number 7A to 7B in respect of their total 1/4 share. Lord, here the plaintiff has sought for declaration that the deed is void because of the thing, the fraud and the coercion was practiced upon them. Lord, the section 16 of the Contract Act says all the transaction is the outcome, all the transaction which are outcome of the fraud, misrepresentation, coercion is voidable, voidable and not the void deed. In the first where the plaintiff has asserted that there is a fraud, coercion and there is a misrepresentation. Therefore, it is the voidable deed, not the void deed.
Very well.
Lord, my next contention is that learned judge has held because it is the void deed, that is why the deposition of the PW1 will not be considered, although she has the knowledge. Lord, my submission before your lordship is that when the issues is framed under order 14 rule 2, then the learned judge ought to have considered the both facts and law. Learned judge cannot say that I will not look into the deposition of the PW1.
Before holding that, the learned judge must have held that it is void because of some reason.
Yes.
So that issue was ultimately decided, had to be decided.
Yes.
Because
So
unless the trial judge decided that issue, that because they have sought for, that is the first declaration.
Yes,
That issue must have been decided by the learned trial.
learned
But the
judge,
learned trial judge said that issue is not required, the declaration is not required.
not required.
But unless that declaration, that issue was raised and it was decided in their favor, would not come to the next finding.
Next findings. But the learned judge has held, my lord, page 23, page 223, I have pointed out from the paper book.
Yes, put the proposition topsy-turvy. I mean, head over heels sort of. He should have said that unless he declared it to be void, he could not have said that whether it's partition is a primary relief.
Yes.
Understood. Very well.
Next, Lord, I am showing some circumstantial evidence to show that deed of partition was acted upon. Lord, the page 103 first.
Whose evidence? PW1.
This is the PW1.
Kamala.
Formula.
Hmm.
Middle portion.
Hmm.
Sentence starts with, I have signed upon the partition deed at first week of April 1979 at afternoon at Alipur. I, along with Gopeshwar Mollik and my husband.
You made it bold in bold letters.
I did not, Lord. This is the certified copy, Lord.
Certified copy, it was bold letters.
My Lord.
It's in bold letters, but the trial court overlooks this. Yes. No, does not overlook. It is looked into, but says that I won't.
Consider what against me.
Right.
My husband Narayan Rokit went to the concerned registry office. It had been taken an hours to complete the registry proceeding. The expenses of the registration work has been beared by my maternal uncle Gopeshwar Mollik. We all alone returned after registration. I do not know whether the shoot property, shoot land has been mutated or not. I do not know whether the tax has been paid in connection with the shoot land or not. Defendant has been possessing half share of the shoot property. Rest half share is belonging with us. We, the defendants, have been residing at the shoot property since 1958, that is more than 50 years. Narayan Rokhi, during his lifetime, never wrote a letter to Gopeshwar Mollik or his legal heirs of the Gopeshwar Mollik, as his signature of the said partition deed was taken by force. Narayan Mollik, during his lifetime, never complained to any court or registry office that his signature was taken upon the partition deed by way of the force. I did not file any suit before any court of law challenging the partition deed. Next, Lord, the page 142. That is the deposition of the second defendant.
Kamala was plaintiff 3.
No, Lord, Kamala was plaintiff number 1.
Sure.
Yes, Lord, he was the plaintiff number 1.
All right.
Kamala was PW1, plaintiff number 1. And Durga was, Lord, the
2.
2 and Lord, the PW5. Page 142.
No, probably that is in the amended plaint, because in the body of the plaint somewhere it's written
Yes, this is the amended plaint.
amended plaint. Please come to page 19. No, I'm mistaken. You're right. She is mentioned at plaintiff number 1. So Kamala was plaintiff number 1 and PW1.
PW1.
And this PW5 is plaintiff 3.
Plaintiff 2. Plaintiff number 2.
Oh, there are 2 plaintiffs.
Two plaintiffs.
Right. Very well.
Next, Lord, I was indicating, Lord, the page 142.
Yes, we are there.
Lord, the middle portion. The sentence starts with the quantum of land is 4 kata 5 cheetahs and 4 square feet. We are residing in the western side of the land. Defendant are residing in the eastern side. There is a big wall, a brick built wall over the shoot land.
There is a partition wall in between the 2 houses.
Yes, Lord. And in one side, there is a land measuring about two kathas and few chotas, and on other side, there is a land measuring about 2 kathas and few chotas. It is the partition wall in between the two houses constructed in the year 1959.
He says my mother searched for Santosh Rokit for 1 year.
Yes, because of the fact, Lord, they kindly come to page 94 once. I am indicating from the page 94. The Komala married Santosh first.
You said during subsistence of that marriage, the same
Yes,
marriage.
during subsistence of the first
What was
marriage.
the year of that marriage? Before 1955?
Oh, Lord, that is after 1950. Although I could not prove this thing.
Anyway, yes.
Now, that is why, Lord, this is my submission regarding the point of limitation, and the shoot property was factually partitioned. Now, Lord, regarding the existence of the Lolita. Lord, it is fact, previously, Lord, I filed the written statement in court below. There I made an admission that regarding the existence of the Lolita. Subsequently, I filed an amendment application, and my amendment application was, Lord, the allowed, and that is thereafter, Lord, the phrased written statement was filed. That order was not challenged by my learned friend before this honorable court in civil revisional application. And learned judge, findings of the learned judge kindly come to regarding that he argued before the trial court on this point at length, and the findings of the learned judge in favor was in my favor, page 193. Paragraph 2.
Yes.
Now, Lord, I will place the section 50 of the Evidence Act.
Is verifying that I am human. Yes, I am a human. Yes. Yes. Opinion on relationship. Place it.
When the court has to form an opinion as to relationship of one person to another, opinions expressed by the conduct as to the existence of such relation of any person who is the member of family or otherwise has special knowledge, special means of knowledge on the subject is the relevant fact. Now, Lord, my learned friend has produced the PW3. Now, Lord, kindly see who is the PW3 first. From page 94, I am placing the who is PW3.
Yes.
Jugal Kishore Mullik's second wife's son.
Let us find out Jugal Kishore first.
Lord, the top Lolita just below the name of Lolita.
Yes, Jugal Kishore.
Jugal Kishore Mollik's second wife's son.
Who is Jugal Kishore Mollik's second wife?
Jugal Kishore Mollik was the
He is not there in this.
no, he husband of the Lolita. Jugal is,
Second wife's son is not a member of the family of Lolita.
that is the case, Lord. That is the case. PW3 is the second son of the second wife of Jugal Kishore.
So his evidence was relied on to hold that Lolita exists.
Yes, and I will show his evidence regarding the first wife of the Jugal, not the daughter of the Indumati. PW3's whole evidence regarding the Lolita was the first wife of Jugal, but in nowhere she said the Lolita is that proof that Lolita is the daughter of Indumati. Lord, kindly come to page 102 onwards. Lord. 196, Lord, this is my mistake. 196, page 196. Page 196, first paragraph.
Yes.
Now, this court is to consider whether plaintiff could prove the exhibit 19 series.
What was exhibit 19 series?
That is that documents,
Panchayat.
reply of the municipal chairman of the municipal.
Yes, yes.
19 series and the contents therein, and existence of the Lolita Mollik and her two daughters named Ostukona and Kamala Rakshit. As per the version of the oral evidence of PW3, Lakshmi Kanta Mollik, his father's first wife was Lolita Mollik. PW3 was cross-examined at length. During his cross-examination, PW3 stated that he was born in 1946, that he has the document to show that Lolita Mollik was the first wife of Jugal Kishore Mollik, that he was not born at the time of their marriage. He has not seen the Lolita Mollik. In cross-examination, he is found to be the firm and stick on the point and say that truth that he was not born at the time of the first marriage of his father Jugal Kishore Mollik, and he had not seen the Lolita Mollik. The son of the Lolita Mollik is the best person who can state truly.
Son of the second marriage could not have been born at the time of first marriage.
Yes.
Obviously.
Next, if any marital status of his father Jugal Kishore Mollik. Next, Lord, the observation, kindly consider the observation of the learned judge. No inimical relation in between the PW3 and the defendant has been pointed out during the cross-examination. PW3 stated that Lolita is the first wife of his father Jugal Kishore Mollik. Therefore, on demise of the Jugal Kishore Mollik, his property, if any, would be devolved upon the legal heirs of the Lolita named Kamala and Ostukana. And on their demise, their share, if any, would be devolved upon the subsequent legal heirs of the Kamala and Ostukana. And meaning thereby, share of the PW would be the less if he admits the Lolita to be the first wife of his father, Jugal Kishore Mollik. Despite the fact, PW3 went on saying that his father's first wife was the Lolita Mollik, as the PW3 was giving evidence against his own interest. Now, Lord, this entire evidence of the PW3 is beyond the issue. Issue was that whether the Lolita was the daughter of Indumati or not. But here evidence has come that Lolita is the first wife of Jugal Kishore. And Lord, the second thing the learned judge has observed
that as there is no inimical relation between the plaintiff, between the PW3 and the defendant, that is why the evidence of the PW3 shall be considered as the best evidence. But the section 50 of the limitation, section 50 of the Indian Evidence Act does not permit the learned trial court to adjudicate the relation in such a way.
Yes.
Now, Lord, the very vital evidence, that is the PW1. PW1 is saying Lolita is not my mother. Kindly come to page 102. There is admission, Lord. That is the blood cross-examination of PW1.
Yes.
Blood at bottom. I do not have any documents to prove that Lolita was my mother.
Because she has no document to prove.
And next page 103 is very much important, Lord. Straightway kindly come to not a fact that Lolita is my mother.
All right.
Now, Lord, the learned judge has said, has proceeded on the basis of the Exhibit 19.
Yes.
Now, kindly come to Lord, what is Exhibit 19? Page 330, second part, Lord. That is the Exhibit 19. Lord, first of all, Lord, kindly Lord, see the contents. As per your requirement, letter was addressed to Manavendranath Thakur. He is not the parties to sue. As per your kind requirement dated 26 September 2026 under Right to Information Act 2005, this is to inform you that the requirement of certified copy of the affidavit dated so, certified copy of the certificate dated 15th September 2016 regarding the legal heirs of the Jugal Kishore Mollik are being supplied to you and on behalf of your client Srimati Durga Chakraborty. So, Lord, he has given the certificate regarding the legal heirs of the Jugal Kishore. But the issue was that whether the Lolita was the daughter of Indumati or not. Now, Lord, my Lord will find from the Exhibit 19 that it is not being certified by the issuing authority.
No, this is the total Exhibit 19.
Lord, that I find. But I have the doubt regarding.
I also have my doubt.
But
The Cormac, have you checked up the records? Cannot be the entire.
what I have.
Yes. There are certain certificates also.
But what I was supplied with, Lord, was the entire reply also.
Yes, should be.
That, Lord.
Lord, this is the only the documents was page 182. My Lord will find page 182 of the first part.
Have you checked up from the records? Should have checked up from the records.
Exhibit 19. Reply on the basis of the application under right.
And the documents have.
And documents supplied therein, though it is inadvertently marked as exhibit.
Maybe.
That means, Lord, these document was only the marked as exhibit. The documents were not marked as exhibit.
accompanied document of exhibit 19 was not.
No, no, exhibit 19 itself was inadvertently marked as exhibit
Yes.
7. The document is, exhibit 19 is reply on the basis of application under RTI and the documents supplied thereon.
Next plot within bracket, though it is inadvertently marked as.
The entire thing was inadvertently marked as exhibit 7. If you go to exhibit 17, you will find the same. That was inadvertently marked as exhibit 616 and should be read as 17. So what was marked as exhibit 17
Exhibit
should have been exhibit 19.
Yes.
Exhibit 19 says reply on the not only the reply, whatever is in the brackets apply to the entire thing. The entire thing is reply on the basis of application under RTI and the documents supplied thereon. Documents must be a part of the record.
But my instruction, Lord, this is only the
You
letter.
should have checked up the lower court records.
Yes, sir.
You have the records.
Yes, Lord.
These are the original records.
They are the original record. Stamp, stamp.
Yes. Just try to find out either 17 or 19, whichever.
The marking হয়েছে এটা গেছে এটা মার্ক দিয়েছে mark for identification. Then এটা পেছনটা দেখো এটা mark for identification. No, but only this is was marked as exhibit. Other document as it is reflected marks.
This has been marked as there's a stamp of exhibit 19.
Exhibit 19 only that certificate.
You have seen that?
Yes, yes. But other document was it has been the X for identification.
Then cannot remain.
ওটা একটা করে দাও এইখানটা দাও
That document proves nothing.
Perhaps not it was marked. The reason is not initially.
Perhaps won't do. The records are different.
Not initially there is a stamp of not mark for identification, but subsequently not exhibit 19 stamp is also there. So on the affidavit as a bunch it went. Not kindly have a look at it.
Was
For the third flag. For the third, the last flag. হলুদ flag থেকে শুরু last flag. Because Lord, this is the entire bunch of Lord the exhibits. So 19 was marked as a whole. Marked for
17.
X for identification.
The final 19.
হয়েছে
Marksheet আছে corrected
This
করে
is the
19
original.
করেছে পুরোটাই গেছে
Perhaps that's the photocopy. This is the original that I have. That is the photocopy.
original you took back.
No, that is what I find.
Why don't you return before the এটা রয়েছে
Subsequently, you know,
those are also part of your paper book in a previous page probably. Marksheet we saw. Marksheet we saw in the paper book, your paper book. Please check up.
not exhibit 19 perhaps
17,
not
yes.
contain Miller mark sheet. Exhibit 19.
17 has been subsequently marked as 19. It's written here.
Not
17, then corrected by with a judgment dated such and such. Exhibit 19. Here it's there.
but that exhibit 19 is this bunch.
Mark sheet is the first document of.
Lord, the first document is, Lord, the Office of Councillors, this letter of RTI.
Oh,
And Lord, the subsequent documents. Those are, Lord,
that is at the end.
Yes, Lord, should have been. Lord, this is the original. Kindly, Lord, have a look at this. This is the original one. Your Lord, should find the first two were marked for identification. Thereafter, Lord, because it was certified by the issuing authorities.
As per required.
হ্যাঁ, ওই জন্যই তো পরে এক্সিবিট মার্ক হয়েছে। না, তোমার এখানে ইয়েটাই নেই,
আমি তো ডাইরেক্ট নলেজ
পেপার বুকে ওই পার্টটাই নেই।
2016 চেয়ারম্যান রেকর্ডস থেকেও বললে তোকে বলতে হবে কি রেকর্ডস থেকে রিপোর্ট নেবে না, কিছুই নেই। এটা তো লক্ষ্মী স্থান, হ্যাঁ, not impressive, does not prove anything.
I'll try to.
Your affidavit and
But
in
entire
20
bunch was the issuing.
yes, entire
authority
bunch, we are
certified.
looking at the entire bunch. The entire bunch is not
But the
does
in-
not prove anything.
Lord, the issuing
To
authority.
whom it may concern, issuing authority 2016 relying on what? Cannot have any direct evidence. This is not a certified copy of anything.
But that's why the certificate perhaps was issued by the.
Who is he, the Ghatal chairman, the chairman of the Ghatal municipality, to give a genealogical table and say that this person? What is the basis of his knowledge? Where does he derive this knowledge from?
I'll try and make my submission.
This is not a certified copy of a death certificate or a birth certificate.
Not a certified
Under which
copy.
provision does he give it?
I'll Lord,
To
try.
him whom it may concern. I know Mr. Kormakar is a bad boy.
Certificate of.
I am the chairman of the whatever municipality you are, or whatever boy. I mean, but that it's like that. To whom it may concern, certified that late Jugal Kishore Mullik was an inhabitant of such and such. He died on 84 and 2016. Ghatal municipality chairman knows.
Corroborated. This has to be corroborated with his son's evidence.
Son's evidence.
His son had come for evidence.
Son wrote an affidavit on the basis of this. It is a copy paste of the son's affidavit.
Son has come forward for deposition. The son had deposed.
Son's deposition, we'll see.
Yes, Lord. Thereafter,
this is
in
nothing.
corroboration with that.
What corroboration? He cannot corroborate. This is not a corroboration of anything. Independently, this has no value.
My
It
lord,
is based on the affidavit of the son.
the genealogy of Lord, the heirship certificate that has been issued.
To whom it may concern, he gives the genealogy and the family member's name. How does he know? 2016 chairman of Ghatal municipality knows that in 1984 Jugal Kishore died. He resided where? And it should have reflected at least the source of his knowledge. What is the source of his knowledge? Nothing. He does not even disclose that. Source of his knowledge is in the next page. The affidavit by his son.
I'll make.
Anyway.
Try and make my submission.
Yes, yes. No, you'll also show the other evidence. Yes. So yes, Mr. Ghosh.
Lord, my third contention regarding Lord, the exhibit 19 was that exhibit 19 was beyond the pleadings. And exhibit 19.
Evidence need not be pleaded.
Lord, I will show one judgment, but only one paragraph. Lord, kindly come to page 197 of the first paper book.
Record ta ferat nahi nunke.
Findings of the learned judge.
Yes.
Paragraph 2. Now, this court is to consider the admissibility of the exhibit 19. The exhibit 19 series is written information obtained under the Right to Information Act. And it was accompanied by one affidavit shown by Lokhikanto Mollik and one heirship certificate issued by the chairman Ghatal municipality. It is the case of the plaintiff that Lolita is the daughter of Indumati, and the said Lolita had the two daughters named Oshukona Das and Kamala Rokhit. And therefore, the plaintiff is to adduce the evidence and the document to prove the same. The fact constituted the fact provincia need not to be stated in the plaint. Only the fact provenda is required to be stated in the plaint. Herein, the fact that Lolita is the daughter of Indumati and Lolita had the two daughters, Oshukona and the Kamala, are the fact provender and which is required to be mentioned in the plaint, then based on the paragraph 4, page 196, paragraph 4.
198.
Sorry, 198, paragraph 4. On the other hand, learned advocate, paragraph 4, one yearship certificate duly certified by the chairman of the Ghatan municipality has been supplied with the Right to Information Act. Now, whether it is admissible in evidence, the answer of this question has to be given in unreported case titles and so on, so on. So, wherein it was said that clause 5 of section 65 of the Evidence Act make it clear that a certified copy permitted under the Evidence Act and by any other law in force can be treated as secondary evidence.
This is not a certified copy at all.
This is not a certified copy at all.
You have prepared the paper book instead of the trial court judgment particulars. You have written Justice Tandon and Justice Gangobadhyay's order.
This is my mistake. Very fast, my lord pointed out these things.
So that is the first thing we look at after looking at this judgment. Anyway, yes. So this 19 also goes. What else? What else remains? So if 19 goes and there is no other proof, no, Mr. Kormakar was referring to evidence of son that must have been considered by the court. Let us see that. Jugal Kishore Mullik and yes, para 6 probably, page 199.
Lord, I am referring, Lord, one judgment, paragraph 200, SCC 2018. Follow.
Which year?
Volume 11, SCC, page 119, paragraph 19 to 25.
PW3 is that person who was not born.
PW3, yes. PW3 is the son of
Second wife.
second wife.
Yes.
But without wasting my lord's time, I am reading only the paragraph 19, last two lines. Paragraph 19, last two lines. Any
Yes.
amount of the evidence or the proof adduced without there being proper pleadings is of the no consequence and will not come to rescue the parties.
This does not say that the proof has to be pleaded. Rather, it's well settled that the evidence need not be pleaded. But the foundational facts for adducing that evidence must be pleaded. Foundational fact they have pleaded. This does not help you much. But we are not convinced with the subject to hearing, Mr. Kormakar. We are not convinced with the evidence itself. Court says that PW3 was not born at the relevant point of time. His evidence coupled with that chairman of Ghadal municipality, his certificate together corroborate each other apparently.
Moreover, Lord, the issuing authority was not brought on
But it's like the visually impaired guiding another visually impaired.
Yes.
One was not born at the relevant point of time. The other had no occasion to know anything. And it's not a certified copy at all. It's his own opinion.
Yes. And the issuing authority was not gave their evidence. I could not even
Issuing of what?
Which chairman of the Ghatan municipality or any officer.
What would you prove? That certificate has been issued? What is the value of that certificate?
He has
to
issue such type of certificate.
Sum and substance of my argument.
Put in short written notes, Mr. Ghosh, because we have already lost track of some of the points, so that we don't miss out any point. Very short. We have taken our own notes. We'll just corroborate with you whether we miss out anything or not. Yes, Mr. Kormakar.
I'll start, but kindly permits me to conclude some other day.
Why?
But a few things.
You have to take permission from the chairman of the Ghadal municipality.
I'll start, Lord, else Lord takes it up some other time.
Why?
I can start, Lord, but kindly permits me to finish some other time.
Why?
Lord, some of the judgments, Lord, I have. Lord,
But then what is you starting today?
Lord, next week then.
No, then no, otherwise. No, Mr. Kormakar will make substantial arguments today. Because we can, part hard matters, we cannot afford that.
Wait,
We
right.
won't make, because we have to then make some other matter part hard. Your item is item 4.
Yes. But
Let us. Item 5, both sides are present. You are for one side, you are Miss Poddar. Who is for the other side? You said, can you inform him? If he comes, then we'll release Mr. Akram. No use creating a farce. You start, but don't waste time. I mean, make your points, whatever points you are ready with.
Lord, first and foremost, Lord, kindly comes to exhibit number 11, page 299. Lord, the second. Lord, because the entire question was with respect to existence of Lolita. Lord, whether she was the wife of his, wife of mother of Kamala.
Wife of was not so
the
important.
existence was in.
No, no, existence, not only existence, whether she was the daughter of this
Indumati.
Indumati. That is.
Lord,
Lolita existed, maybe. But whether she was a daughter of Indumati, that is most
Lord,
important.
they are questioning Lolita's existence first.
All right.
Indumati is the secondary. First existence.
No, for the suit, what would be Germany is whether she was a daughter of Indumati.
Yes.
Isn't it?
Lord,
Because if she was not a daughter of Indumati, then nothing would have changed, would it?
Perhaps not. Perhaps.
No, but if she was a wife of Jugal,
If the defense was,
suppose if the defense was that she did not exist and you prove she exists.
yes.
But there is no proof that
But
she is the
then
daughter.
they're questioning. Huh? Then their question.
Will come.
I will come by 10.
Very well.
Then the question, Lord, of whether she was the mother of Kamala or not, perhaps will not have its footing.
I said Lolita Mullik is daughter. No, does it matter if she is the wife of Jugal? Wife of Jugal was admitted.
Wife of Jugal does not matter.
So daughter of Indumati matters.
Matters.
Yeah. Then should disturb the entire line of Mr. Ghosh's client.
Yes. Plus,
Very well,
because
very
in any event, Kamala will have some interest because of Lord Narayan. That interest she has.
Even in that partition.
Yes. This is with respect to the other half, claiming
Right.
the other half.
Right.
That's why your lordship would find, Lord, there are two set of charts.
Very well. Which
Page
page?
94.
Page?
94.
No, you are.
Achha, Lord, page 299.
Page 299. What is
This,
299?
my lord, is the letter issued by their advocate in reply to my learned advocate's, my lord, letter. Lord, 299 it starts.
This was an exhibit.
Now, this is exhibit 11. This is exhibit 11.
All right.
My client, along with her mother and sister, are enjoying the possession by paying taxes year after year, such and such, that it should not go without mention that the property in question was solely from the fund purchased solely from the fund of Gopeshwar Mullik for the pleasure of her mother, Indumati. He entered into an agreement for purchase of such and such, who had no income before the payment of full consideration. Indumati died, leaving behind Gopeshwar Mullik and daughter Lolita Mullik died on 1935, long before the agreement for purchase. This is on
Advocate's
instruction.
letter on instruction. It's not a part of the pleading or evidence.
Admission. Look, this is an exhibit. This is an exhibit. It is an admitted position that this learned advocate was acting on their instruction, Mira. Lord Mira, you're not so fine.
Advocate's letter.
The last Lord of the.
Mira is one of the appellants here.
Yes. Plaintiff number. Mira plaintiff number. Chapter 8. Mira Milord is defendant number 6, not play. I'm sorry, defendant number 6.
Yes,
This is
but
one.
then she's an appellant.
Copy. Xerox করতে বললাম? So this is 2020, volume 13, SCC 188.
No, what is the other, any, no context given to this reference to Lolita? in this letter?
Yes. Lord, that's the line.
For the pleasure
sentence.
of her mother.
Accordingly, Lord, the second paragraph in 300. The last sentence, Lord. Accordingly, the deed of. Huh. No. Lord, I'm sorry. The last line of the first paragraph in page 300.
Yes.
Indumati died leaving behind Gopeshwar Mollik and the predeceased daughter. Lolita Mollik died in the year 1935. That's the admission.
Acha. So predeceased daughter, apparently Lolita is
So
included.
not only the existence is admitted,
But
that
it's stated
even the daughter
Lotika.
for Indumati.
Lotika, not Lolita.
Lord, that perhaps not.
This is not an admission then.
Lord,
Admission has to be
Lord,
strict.
it is nobody's case that not Lolita, there was an existence of Lotika. Predeceased daughter Lolita, and subsequently everywhere in the evidence.
Everybody's case that Lolita.
Lolita.
Lolita is the crucial factor. Lolita, whether she was.
And there was no existence of
There is no
Lotika
admission.
also. Because.
Lotika may not be, but he admits only to the effect that Lotika Mullik died in
Existence
the.
of a daughter.
Lotika is that daughter, not Lolita.
Now, my lord, they say in their defense that Gopeshwar was the sole son. There was no existence of daughter.
Acha, right.
So, Lord, if there
Sole
was,
child, actually.
yes. So, my lord, this defense is, Lord, frivolous on this basis itself. Now, my lord, this Lotika or Lolita, my lord, that can be a typographical error, whatever
Let us
it is.
proceed
But
on
the
that.
existence of a daughter is there.
All right.
And I say, my lord, that daughter was Lolita.
But admission has to be taken as a whole.
Yes.
If it is taken as a whole, she predeceased.
It is my case also. It is my case also. Lolita died, my lord,
Before Indumati.
1934.
But her heirs, the lineage remains.
Yes.
So therefore, they have a share in the.
That's why Jugal Kishore married the second time, and that's why.
That's why means for the property.
That's
why that's why.
Not the reason why PW.
Lolita was the first wife.
Lolita was the first wife. Jugal Kishore married. Thereafter, after the demise, Jugal Kishore married for the second time.
Yes.
PW3 is there for that. Now, Lord Kamala was born by that time, Kamala and Ashrukana, out of the first marriage. That is what my case is based on. Lord, with respect to the judgment that I was citing, 2020, 13 SCC, the page 188.
You claim through Ashrukana?
I came through Kamala. I claim
Kamala.
through Kamala. Lord, paragraph is.
I've got a copy.
12, 13 and 16. Yes, Lord. Only one copy. Lord, may I read it out and then, Lord, hand over the other copy?
No, we'll find it out. What is the citation? Sorry.
Lord, 2020, 13 SCC 188.
Which paragraph?
Paragraph number, Lord, 12, 13 and 16.
Whichটা কথা বললে?
188.
188.
180. May I place it, please?
Yes. Which paragraph?
Para 12, 13 and 16. I'll start from 12.
12, right.
The moot question is whether the appellant should be bound by the statement made by his counsel before the High Court that the respondent tenant will be such and such. So, Lord, this was the question. From the tenor of the statements made before the High Court on behalf of the appellant, it is obvious that it is unequivocal statement made by the counsel engaged by the appellant to espouse his cause before the High Court. It is not the case of the appellant that he had expressly instructed his counsel not to make such a statement. Further, the statement was in respect of a commitment, not the facts of that case. 13. Considering the above, the appellant cannot now be allowed to resile from the statement made before the High Court, which the High Court justly declined to undo the review petition filed by the appellant for that purpose. In Lord, thereafter, the engagement, Lordship kindly got it. The engagement was in respect of eviction proceeding, and the statement was in relation to the commitment of the appellant qua the state subject matter thereof, and being an unequivocal statement, it will be binding on the appellant. Lord, thereafter, the court relies on some judgments, Lord, and 16 is important. Perhaps not 12 and 13 will do.
But
Lord, my question is,
but
the answer,
statement made before a court, particularly a High Court, that has its own connotations also.
Right.
And there are sanctions.
Lord,
340 will come in.
Lord,
That
here,
cannot be equated with a letter written to the other side.
the context was,
Pre-litigation letter.
the context was the previous exhibit, that is exhibit number 10. That is, Lord, kindly come to 9. I'm sorry.
It can either come as an admission in pleadings or in evidence. In evidence, you exhibited that, but the intrinsic value of the admission is in that document, not as an, I mean, it's not oral evidence. Somebody did not admit. It's not the party writing.
This content of this letter was admitted because this went as an exhibit. Arguments were
It was
forwarded.
did not go with objection.
No objection, nothing. Kindly sees the context. That's why, my lord, I'm inviting your lordship to seek exhibit 9. Kindly comes to 293 once.
Yes.
This was written to them, to the defendants. I'm sorry.
Yes. Page?
Page 293, exhibit 9.
Yes.
This was written to them. This was the first letter on 3rd of October 2012. This was written on behalf of Kamala Rokhit and Durga Chakraborty, seeking partition. Lawyer's letter. My lawyer's letter to the defendants. In reply to this letter, Lord, here I state categorically, kindly, my lord, comes to page 294, the second paragraph.
Yes.
Regard being had also to the fact that the Indumati died intestate, leaving behind her son, such and such, and Kamala and Oshrukana, both daughters of predeceased daughter of Indumati, namely Lolita Mullik.
Yes, yes.
This was my context.
Yes, yes.
In context to that, he replies, not admitting.
Right.
So, my lord, after issuing this letter and allowing this to get as an exhibit, now it does not lie.
It was in reply to that letter.
Yes.
The context is very specific. Very.
And Lord, that it was referred to that 299, your Lord should find from the reference itself. That your letter number 3rd October 2012, such and such too. So this was the context. And in that context, she admits.
But give another copy of the judgment.
Yes, Lord,
for the records.
definitely I'll do that.
Yes. Otherwise, you cannot take notes, physical notes.
Lord, I understand, Lord, Mr. Rai is here. Lord, today may I.
Very good. And one other aspect, limitation also you have to overcome.
Yes, Lord, limitation with respect to limitation, I will argue, Lord, I'll just indicate, Lord, my argument will be, the first relief is with respect to partition. The declaration that I've sought for.
Without the declaration, how can
the declaration that I've sought for is basically of a document which is void ab initio. A document which is a nullity in itself, which should not have seen the light of the day. Lord, no separate section 31 application was required. The application of section 31, Lord, is
but
not.
The judgments, one of the judgments cited by himself, yes, maybe a nullity. But even then, if you file a suit, then the residuary, some provision would apply.
I'll try and deal. I'll try.
Third in part for further hearing on, we'll keep it on Monday. on February 24, 2025.
Great. That's it. Lord, I shall supply to your lordship.
We do that. ও দিলে ওটা
Today.
উপরে একটা আর লিখে দেবেন। দিয়ে জাজমেন্ট গুলো সঙ্গে দিয়ে দেবেন।
Lord, only one leave, Lord. May I take back that copy, photocopy it and give it back to your lordship, Lord?
Which copy?
Lord, the 2020-13 SCC.
Last
Immediately
judgment.
just I'll just, Lord, give it.
Give 2 copies with
Yes.
them. Thanks. বললাম ডিকটেশন দিলাম তো Hardly part for further reading.
Item number 5.
Yes.
We have submitted the lot,
Pardon, Mr. Chairman.
we had finished submissions on our part.
They'll have to.
They'll have, but if your lordship wants, may I just once recapitulate what he had said? If your lordship remembers or not, I don't want to submit.
Just recapitulate once. You are challenging what?
Injunction.
Order 13 and Rule 4 rejected and injunction granted? Or the other way around?
Lord, initially they filed a suit where, my lord, till this court, they were unable to obtain an order of injunction. This was a school, my lord, which is being run in Park Street, my lord, from the Kandani mansion. They are tenants, my lord, with respect to our premises. They now want to, my lord, get hold of, my lord, an area which is adjacent, my lord, to the tenancy, saying that it's a playground which is a part of their, my lord, their school. Initially, they filed a suit. They prayed for declaration of that.
They have a title deed regarding the suit?
No, no.
Regarding the suit.
Nothing. My tenant. And on a tenancy is on a separate premises. That's admitted in the second floor. They are, my lord, now claiming a right, my lord, on the driveway, my lord, which goes into the property.
Right on the basis of, on the strength of what?
Yes, ma'am. On the strength of nothing. They are saying initially they said, my lord, there was a license. In license and easement. My lord, I'll take your lordship to that prayer once. So that would be, my lord, it'll be a little bit clearer.
It's their suit.
Their suit. Old suit. Kindly turns to page 55 once. Huh? 55 though. No. না আমার এইখান থেকে বলা হয়
Yes, licensee.
মালো
Page 73.
মালো lordship got that plot.
Yes,
And then
license.
also sees the present suit. Lord kindly looks to the schedule one. এই জন্যই মুশকিল।
You have not filed any counterclaim as yet?
No. We, my lord, in that suit, my lord, where they are there, my lord, as a tenant, we don't want them to be evicted right now.
No, this is regarding
Right now.
the suit
This
property
is-
must be different.
It's different. That's why kindly
In
see the
this suit,
schedule.
we said that we are saying that asking you that you have not filed any counterclaim for eviction.
No. My lord, they're not in possession.
Or
at
did
all.
you deny their position?
Completely. And they are, I'll show your lordship, they'll admit that. See 73 once.
Yes. Licensee for use of the said
And then sees the schedule.
irrevocable license.
My lord.
Yes, near the school premises.
Exactly. The said playing ground and a lawn referred to herein above is situated near the school premises at the southern angle of
So
Karnataka.
virtually easement sort of thing. Quasi easement has been sought. Like an easement.
For a playground to be used as a licensee, there can't be an easement. Easement would have been, my lord, if he was claiming a right to get into the tenanted property, that could have been easement.
Of a necessity.
My lord, that's an easement of necessity.
Prescriptive right may also be there, long user.
Absolutely. If
There are
were-
tenants in when?
Their tenancy is on the second floor.
Tenants since
Long time. We have a suit pending for eviction, my lord, on that also. That's a
Uh,
separate aspect altogether. Initially, my lord, they file, kindly see the first suit now.
They are saying that it's an irrevocable license, which is a concept unknown to West Bengal
Yes.
because the
97 Supreme
Easement Act is not.
97 Supreme Court 1041. Kindly looks to, my lord, the first suit first.
Yes.
The plaint once. It is
What is that?
73.
Which page?
73. It starts off, my lord, from,
No, that is the first suit.
yes, my lord, 55.
Page 73 is the prayer of the first suit.
First suit. 2015.
Also.
Order below that. Harrow Hall,
Yes.
Karnani Properties is me, my lord. And then the prayer is at 73, where, my lord, they are praying for easementary right and then license. A easementary right and then a license.
Oh,
Mutually destructive.
Yes, yes.
Then your lordship has seen, my lord, 75. That's the, my lord, the schedule. Then kindly looks to, my lord, the order which was refused in that suit. 115. Plaintiff has filed a suit for declaration. My lord, kindly got it?
Yes.
Injunction against the defendants along with an application under Order 39 Rule 1 and 2 read with Section 151 with a prayer for an order of temporary injunction restraining the defendants from interfering and or restraining the students and teachers if the plaintiff from using the said lawn and or playing ground along with an order of injunction. My lord, your lordship turns over. I'm not going to trouble your lordship. Kindly sees 117.
Yes.
Issue notice, that's the second paragraph. On hearing learned lawyer and also on perusing the documents filed by the plaintiff, it appears that there is no dispute that the plaintiff is not at all the owner in respect of the said lawn or playground, though the students and teachers of the plaintiff's school are all used the said playground of lawn with the permission of the defendant, and thereafter the defendant was compelled to fix a signboard that the property is under the possession of the joint receiver appointed by the Honorable High Court of Calcutta. So under such circumstances, it appears that the matter is now pending before the Honorable High Court. More so, the plaintiff has failed to prove any prima facie case, so prayer for injunction is refused at this stage.
Owner, it was not even their case
Not
that
even
they
their
had.
case, it was the owner. Turns to Miller 118 and straight away to 120. This is the order which was under challenge before the High Court. Miller looks to 121. Third paragraph. Let us now consider as to how far the learned trial judge was justified in refusing to grant ad interim injunction in favor of the plaintiff. My lord, kindly got it, Lord. In the facts of the instant case. Here is the case where we find that the plaintiff appellant has claimed its permissive possessory right to use the said lawn as playground of the students and teachers of the plaintiff's school. Though certain document regarding grant of such permission allegedly issued by the defendant number 1 was annexed to the injunction application, but no document has been annexed to the injunction application showing that the plaintiff in fact was in possession of the disputed lawn as on the date of filing of the suit and or the date when they sought for such ad interim injunction. Under such circumstances, we do not find it appropriate where ad interim order of injunction should be passed. Accordingly, we hold that the learned trial judge did not commit any illegality. Now comes very important. Mr. Mantosh, learned advocate appearing for the appellant, prays for leave to file supplementary affidavit for bringing the documents on record to show that the plaintiff is in possession of the suit lawn. Kindly marks this. On his prayer, we grant the plaintiff a week's time to file such supplementary affidavit before the learned trial judge. The plaintiff is also directed to serve copies of the plaint, the application for interim injunction, if it is filed upon the defendants within a week.
This was never filed.
Never done. On the contrary, my lord, they have filed an affidavit that they will not file any document whatsoever. In that suit. Forgets about filing, my lord, the entire, my lord, they were unable to, my lord, find out any document. I'm not using a harsher word. ওদের document ওদের কি copy দিচ্ছিস কেন? আচ্ছা যাই হোক। Kindly see paragraph 6 that as a result of the aforesaid failure of communication with the learned advocates of the plaintiff, prayer was made for bringing documents on record to show
that the plaintiff is in possession of the suit lawn, though the possession of the plaintiff as stated here and above was not of a nature that could or should rely on documents for establishment of the same. Accordingly, the plaintiff was advised that there was no necessity to file an affidavit in terms of the leave sought for. on
Paragraph
behalf of the
5,
plaintiff.
5 is also very relevant.
5 was also relevant. I'm sorry, my lord, I should have.
Yes, paragraph 5.
That due to lack of communication between myself and the association which is running the school on the one hand and on the other hand with our learned advocate, it could not be explained or brought on record that the right of the school to use the lawn was a purely permissive possessory right. It is not the case of the school or of the association that they were in possession of the lawn. I'm sure your lordship was looking into that. Now this was what it was. Then kindly sees the present suit. Sees the present plaint, my lord. It is at page 1. And kindly have a look at, my lord, your lordship will try in vain to find that this suit was ever disclosed. I should be, my lord, corrected if I'm wrong. Looks to page 13. Declaration that the plaintiff having easement right, entitled to enjoy
Amrana.
free light and air. Declaration that the agents have no right to block the easement right.
This is the present suit.
Present suit. Page 13, 1-3.
Yes.
This is the present suit.
No, they have not disclosed about the previous suit at
No.
all.
And this is a school. My lord, this is a litigant which should have been, my lord, I don't know, my lord, with a lot of respect. They are teaching this to their students. Then have a look at everything, right to make any construction. He is not the owner, he is not in possession.
No, he claims for free air and light through the lawn. That-
If there is a law. So there is a limit to, my lord, keeping us, my lord,
through and from the should have been over the lawn. I mean,
and then I have no right to block it. Can't, my lord, have a construction being made at D since it's a heritage building, separate thing altogether.
what is the injunction they're seeking now? That they
And
cannot make it
injunction-
construction.
Ekebare. Kindly have a look at page, the next, just the next page, which is, it starts from 19. The prayer is at 36. Order of temporary injunction and its men to block the natural air and light flown from and through the lawn, come playground, enjoying by the petitioner number 1. And the Harrow Hall School being the petitioner number 2 since more than 46 years as an easement annexed to the petitioner's school building by raising and or making any construction upon the said lawn. And kindly have a look at now the impugned order, which is,
Yes. Let us see that.
yes, ma'am. Kindly, ওটা পরে দেখাচ্ছি, impugned order দেখো একই জিনিস হবে।
Yes.
113,
Okay.
113 itu.
Keep going. 115.
Yes, ma'am. 115. আরে এখন যেটা ইনজাংশন দিল হ্যাঁ আইডেন্টারি আরে ইমপিউন্ড অর্ডারটা হ্যাঁ 126
This was the previous order.
yes ma'am. I'm sorry previous 126
Yes.
after my order 39 rule 4 my lord, this order was passed. Lord, I'll read with your lordship. Second paragraph. It appears from the record that both sides were heard at length on the petition under Order 39 Rule 4. The application under Order 39 Rule 4 read with 151 of Civil Procedure Code has been filed by the defendant number 1 with the prayer for vacating under 97 Supreme Court 1041 Barcode. On the plea that the plaintiff has filed the suit and the plaintiff petitioned for temporary injunction by suppressing the material facts, and the plaintiff has filed a prior suit on the same property on the similar reasons in the year such and such, which is still pending before this court, and the plaintiff did not disclose the said fact and they did not approach this court.
Mr. Chatterjee, you should have annexed the previous order also because there he relies on that.
Yes, my lord, it's there.
What is that?
In the paper,
13th of September order.
my lord, we did it, you know, in the application it was there.
Give a copy.
Adding to it.
In the application, it has been annexed.
It was annexed. In the paper book, it wasn't. nature and character, and the disputed suit law. Heard the learned advocate, peruse necessary, the usual orders which have been passed. 1041.
Court says that you failed to lay particulars of alleged suppression. What does that mean? You did not produce the document previous.
Sees my order 39 rule 4 application. Looks to order 39 rule 4 application. জজ সাহেব পড়ে নিয়েছেন অলরেডি, যেটা দেখাচ্ছি, কিন্তু জজ সাহেব অলরেডি পড়েছেন। তারা
Admittedly, permissive possession is also wrong.
My lord. 42 to 47. Have a look at it.
Admittedly, they are not in permissive possession.
Absolutely.
Because they say that
That's the affidavit.
air and light also.
Air and light. And then
The suit
affidavit
also. Affidavit, present suit.
Everything. And it's all there, below at page 44. Copies of the orders passed by this court, paragraph 5, my lord. I could have read it on and on, my lord. There's no reason why
Effect will be lost.
in
then.
this. We are
Immediate effect is-
only apprehensive about.
No, Mr. Rai, yes, you have finished, Mr. Chatterjee. Yes, Mr. Rai, let us block your air and light.
So far, my lord,
To
once
choke
again,
the throat of the litigation.
if your lordship can turns to the order which is subject is impugned before your lordship.
Yes.
আগের অর্ডারটা দেখ মিনিট। Your lordship will find this is the order which was passed. Subsequently, it was extended from time to time. This 8th October 2021. And now, my lord, subsequently, the minor can turn to page 127. This 127, my lord, which is the order impugned before your lordship. The interim order is extended till next date of fixed for the application of the plaintiff. So, my lord, as and when this appeal was moved, whether this order of injunction or subsequently one extended. Now, my lord, can I turn to
39(4) was rejected.
yes, and interim order and this rejected
Suppression of material facts, Mr. Rai.
suppression of material fact, my lord, reimposition of the same, my lord, it continue.
What?
Because reimposition, my lord, the initial order of injunction was granted for a particular time. I filed an application for vacating of the said order of injunction. Subsequently, my lord, the extension of the said order of injunction, it constitutes separate appeal or mere asking for vacating of the order of injunction will suffice the purpose.
If the parent order goes by order 39,
Then, my lord, each order,
what will be extended?
that is each order to be down to be an
Not a reimposition, it's stated extended.
no, my lord, if you lordship kindly consider subject
Last
to
sentence is that.
yes, interim order be extended till next date fixed
Extended.
on the application of the plaintiff. Extended this extension, my lord, each extension be constituted to be independent order.
It would, if the order 39 rule 4 was allowed, interim order vacated and reimposed on fresh hearing.
Subject to question, my lord, if the interim order was there, I filed an application for vacating of the same. The interim order is restricted for a particular period. Whether subsequent extension constitutes a separate appeal or it is a continuation or the enlargement of the earlier order. But if that be so, my lord,
So you say what actually?
that the last order for extension is required to be without challenging the subsequent order of extension.
Subsequently, this has been extended from time to time.
Yes,
So subsequent extensions not challenged.
challenged.
This is the best ground. What are the next ground?
No, if that be so, my lord, then they have to take, they're considering to that fact
We
that
will answer that along with the other issues also. We will compositely decide.
then,
This will go against you.
then we are the person who will be very happy to that.
Why?
Because this is petty for the larger banks. This is the point which is referred to.
Hide that.
Yes, that
We'll try to make you happy.
no. Judgment গুলো কই? Xerox গুলো কই?
And also, what is the effect of pendency before a larger bench, Mr. Rai?
I'm on the, it is referred.
If it's
No.
referred, it's pending before a larger bench, not decided. Supreme Court has deprecated. On that ground, you cannot go on and on and on with the matter.
So,
You have to decide
yes,
independently.
yes.
We'll
Wait.
accept one of the views.
আরে এখানে তো আছে তো কই জেরক্স গুলো কই জাজমেন্টের জেরক্স গুলো কই
Give us the citations also. Is anything written there? Mr. Chatterjee is doubting that also.
Probably this argument was advanced by Mr. Chatterjee. No, Mr. Chatterjee.
As far as you know, both of you, it has to be you, not Mr.
Well, may I read out only Mr. Chatterjee?
Yes.
The Mr. Chatterjee, London advocate.
No, what is the citation?
Yes, my lord.
It's unreported.
It was reported, but it is
This is a major judge. Significant should have been reported.
না কিন্তু রিপোর্ট হয়নি হ্যাঁ কিন্তু আমি ইয়েতে পাইনি
No, there is no case where I have won against him. This is one such case, my lord, which
At least you have got a chance. Let us see whether you can succeed. Yes, Mr. Rai, quick.
এদিকে হাসছে
You are facing a what task? Appeal.
Suit us to sky. Malad, this is in CO number Malad 3762 of 2018.
You got one copy. This is the only copy you have. CO number
3762 of 2018.
3762.
Yes, my lord.
2018 date.
Date 24/12/2020.
Judge.
Advertisement.
Judge.
Just hear my word, Chaji. Mr. Chatterjee, the learned advocate appearing for the opposite party, raised a plenary objection with regard to the maintainability of the aforesaid applications filed under 227 of the Constitution of India. Mr. Chatterjee contends that the identity order of injunction passed in December such and such, which is impugned in CO number such and such, lost its force by January 10, 2018. Similarly, the order extending the interim order of injunction on September 5, 2018, which was impugned in CO number such and such, lost its force after 21 December 2018. He contends the aforesaid application of 227 Constitution of India have become infractions that the petitioner here have not challenged the subsequent orders passed by the learned court of appeal below, extending the identity order of injunction. In support of his submission, my lord, he referred on unreported judgment. Mr. Sachin says the learned advocate for the petitioner seriously disputed the contention raised by Mr. Chatterjee. He contended that the extension of an order implies prolongation or expansion or lengthening of an order which is in existence in the eye of law. According to him, if the original order has no existence in the eye of law or invalid, there is no scope for such extension and the order granting extension cannot have any effect. Such and such relied upon the judgment of the Honorable Division Bench, Suprati Ghosh was relied upon, and also the...
Can you extend something which is not in existence?
That was the argument.
In this case, the injunction was vacated.
Not vacated, subject to correction, my lord.
It was vacated.
No, it was additive order.
There was a gap between extension and...
No, initially injunction granted. That was challenged in one revision application. Subsequently, it was extended, another revision application was filed. But at the time of taking up this revision application...
That is the difficulty, Mr. Rai, of accepting this proposition. Then if there are 12 extensions, you have to file 12 appeals.
That is the argument which I want to advance there. If the original goes, because it is the extension means prolongation of the original one.
They ask for vacating of the original. If their application succeeded, then the original goes.
That is what...
Only the original request to be challenged. All the extensions go.
If your lordship may kindly consider...
But then, whenever there is an extension, during pendency, there may be 10 extensions. There will be 10 further appeals. Absurd proposition. Absurd proposition.
This is reported
in some cases, there are 20, 30 extensions. There will be 30 appeals.
What is following from lordship? That is my argument before the land single subject to question. May I read out?
You are there, the other side there.
Yes, it is the argument is Mr. Chatterjee.
We will accept that judgment. But
I have heard the land advocate restricted parties on the point of maintainability and has considered the materials of record. After going through the judgment relied upon by the learned advocates for the respective parties, I find that the Honorable Decision Bench of this court have expressed divergent views on the issue as to maintainability of an appeal against an interim order of injunction in case subsequent extension have not been challenged. As such, I have the view the following question to be referred to the consideration before the larger bench. Whether an application to...
So this is not an adjudication. It's a reference.
That is pending. This refer... After that, my lord...
This is not a binding precedent at all.
No. It is single... That is why, my lord. It was referred to the larger bench. granting identity will still be maintainable or becomes infructuous upon the said order being extended and subsequent extension are not challenged. This was the term of reference, my lord. Subsequent, my lord, this came up.
Later, give us a copy later on.
I get it photocopy and hand over to your lordship.
Give,
Citation is 2020 SCC Online, Calcutta,
oh,
2277.
sorry, 2020.
SCC Online, Calcutta, 2277.
All right. Very good. So this is a reference.
Yes, this is a reference. And subsequently, my lord.
We'll answer the reference here.
That is a part of the.
না ওটাই নেই
No, thank God.
সম্পদ দিয়েছি সম্পদ সরকার হরিস্টান হিরণময় ভট্টাচার্য হিরণময় ভট্টাচার্য
We'll make the task easy for that bench. Yes.
and subsequently
Mukherjee was appointed as a.
Mr. Mukherjee, poor Mr. Mukherjee. In every special matter, Justice Tandon. Yes, Justice Tandon was the architect.
yes 57B also there.
Everything Justice Tandon appoints Mr. Mukherjee. Mr. Mukherjee is not in a position, I mean, to
And
do the research. No. How can he?
and this is, my lord, the last, my lord, it came up for consideration before this CSBX CO number 3762 dated 8 July 2024.
So anything else, Mr.
No, this is only on the ground of plaintivity. So
No, the other point.
the other ones. তাহলে ওটা ভালোই হয় ওটা হয়ে গেল
Light and air.
light and air, my lord. Your logically considered now, my lord, is looking order 13 rule 4 for vacating of the order of injunction
But you have made contradictory prayers in the previous suit and the present suit,
No.
both of which are pending.
subject to question, my lord.
You say there in the previous suit itself, you have made two contradictory prayers. One is that you claim an easementary right, for which there has to be a dominant heritage and a servient heritage. You don't have a claim as a licensee over that. That's a permissive. That's a right of easement.
Yes.
Easement is not possessory license. And there also you say, really B in the previous suit is irrevocable license. Irrevocable license is incompatible with easement of light and air.
My lord, what is the suit for, my lord? If your logically
Your previous suit was for both relief,
if your logically turn to the
which
First
are
place.
mutually destructive, as rightly argued by Mr. Chatterjee. And here you are saying that you are entitled to enjoy free air and light.
my lord, if your logically turn to page 6, paragraph 14.
Yes.
This is a suit filed subsequently.
You first decide whether you have a right to enjoy that property physically, or you have an irrevocable possessory license over that, or you want the air and light over that.
Mike, that is why, my lord, initially when we filed the first suit, my lord, what is the cause of action for filing of the suit? My lord, can you consider whether this
What is the cause of action?
Yes, my lord, can you turn to the plaint itself once, the earlier suit. Page 55. I'm drawing lots of attention only paragraph 2. That is at page 57. The herald being the plaintiff herein was and is also using a playing ground herein to said lawn, which is near the school premises and is situated near southern angle of the Cardani mention, along with southern side of the road running from the southern gate to the eastern gate of Cardani mention, which is situated at number of premises number such and such.
The C para 3.
Yes, that the students of the said school used to the lawn and playing ground for the purpose of assembly of the students of the school physically training, sports intent.
They assemble, physically train and do sports in thin air and light.
No, at that, at that time when this access was there, subsequently a board was put forward. That is the cause of action for filing of the suit. If your lordship may kindly turn to paragraph 13.
Of the same suit, previous suit.
Previous suit, paragraph 12, my lord. I'll turn to paragraph 12.
Paragraph. Yes.
In a suit is pending before the Honorable High Court, that is mentioned, paragraph 11, paragraph 12. Therefore, the suit, though filed ostensibly for the purpose of enabling the fire and safety measures in respect of Cardani mention, should become a cover to encouraging and forcing various persons who included the petitioner to act on the dictates of defendant number 2 to 4. One of the wrongful action done by defendant number 2 to 4 was to seek a state hearing in March 2014 to interfere with the use of the said lawn or playground by the students of the plaintiff. Indeed, at the point of time the stated herein above, the only overact action of the part of the defendant number 1 to 4 was to affix a board on the portion of the lawn containing a false statement. This property is under position of joint receivers appointed by the Honorable High Court at Calcutta. After that, if you also can return to the what causes for me to filing of the suit is at page. I return to page 66. Paragraph 19.
Yes.
That on September 2014, 29 September 2014, Harrow School closed for the autumn vacation and reopened on October 14, 2014. From the very next day of the reopening of the said school, the Darwans of Division number 1 to 5 tried to a number of occasions to obstruct the students, teachers, and staffs, both male and female, of the from using the said lawn or playground by passing verbal comments. The plaintiff did not complain finally in the formally in writing to the police authorities, hoping that the situation would come to an end. Friendly relationship would be maintained between the parties. The officer in charge of the local police station was informed about the incidents. That on October 22nd, 2014, about 12 noon, this incident was occurred. And ultimately, this suit was filed for the purpose of right to enjoy that property. Page 72, your lordship find. Paragraph 13 and paragraph 33 and paragraph 34. Paragraph 32. What is followed from my lordship that I am making a mutually destructive plea regarding my right to enjoy that property, that your lordship will licensee, irrevocable license, coupled with transfer property under grant. Paragraph 32, my lord, your lordship can consider. After that, the plaintiff says it is entitled to degree of permanent injunction to defend it from interfering and restraining the students and teachers from using the said lawn or playground. The cause of action of this suit arose in or about March 2014. Said lawn playground at the country remains situated such and such within the park of police station within the judicial learned court, which is continuing day to day. So this was initially for the restraining from enjoyment of the property regarding the same.
Come to the present suit.
Yes, my lord. Now the kindly turn to the present suit. My lord, kindly turn to page 9, paragraph 22.
Come to paragraph 15 and 16 once.
Yes, it was mentioned. But for filing of the suit, my lord, narration was given that
You cannot pick and choose. You say here in the present suit, as a matter of fact, the students of the plaintiff school has been using the lawn as a playground.
yes.
Then your prayer is a ruse. It's a ruse. You say it's used as a playground, permission granted, reflects enjoying. You add free and uninterrupted natural light. Physical possession, if you're in physical possession, natural light in any event comes in. Need not be mentioned. Para 16, you say the defendant granted permission to use the lawn as an easement attached to the school premises. And the plaintiff, so therefore, why shouldn't this suit be stayed immediately under section 10?
If you lordship can you consider paragraph 22. Paragraph 20.
Yes.
That on 5/7/2021, the plaintiff number 1 through its secretary under surprise to found the personal officer of Kolkata Municipal Corporation along with the
You just add air and light to playground. Everything else remains same as a suit.
no, apart from that, the digging and also, my lord, that intent the construction.
Substantially, the same issues have fallen for consideration in both the suits. You say you are using as a playground easementary right, you claim the same rights, and you add air and light.
This is one air and light, my lord, counts subject to question, my lord, within the.
Will invoke our suo motu powers to stay this suit under section 10.
My lord, this is lordship can consider to be an.
The relief is a ruse. You just claim enjoy free light.
Yes.
For free air and light. For
For
free air and light, let us consider that is your main relief.
Yes.
Is this injunction in aid of that?
Yes, they try to make.
They not make any construction.
They are trying to make construction with close down the every.
What is the height of the construction
Yes,
which will close the air and light to your school?
That is what my lord kindly turn to.
And my neighbor cannot make a construction because I'm getting air and light.
Subject to question, my lord, if it
Then no construction would be ever made in Calcutta. No construction, I'm telling you, not a single construction in any neighborhood. Only there would be only one house in every neighborhood. Yes, because whatever construction comes up beside that would block the air and light. It has to be reasonable, Mr.
Yes, that is why, my lord, two things.
It's
My
an
lord,
equitable relief.
my lord, kindly two things.
You stop construction of the adjacent premises because your air and light is being disturbed.
And also, my lord, kindly turn to page paragraph 22. Once,
Yes.
my lord.
22, yes.
What is yes converted in which neither the said
So this paragraph 22 of the previous suit or this,
no,
this suit?
present suit.
Yes.
That's at page,
Page
ni-
9. Page
page
9. Yes.
The competent person of the plaintiffs on such and such visited the office of the Kolkata Municipal Corporation and the first time came to know the defendant has amalgamated 8 premises,
Yes.
such and such, which is neither the said lawn cum playground fallen, nor the school premises fallen, but the suppression of the said fact by the practicing fraud showing the said lawn within the area of 47 Park Street. A plan for making multi-story building upon the said lawn cum playground has submitted by defendant, and the building currently mentioned is coming within the grade 2 of the Heritage Act. So the said submitted plan of the building has been referred to Director General Heritage Committee for approval of the same.
Mr. Rai, if your client is agreeable to purchase that lawn from them, we can exclude any option of any settlement between you. Then you have to purchase that portion, and probably they'll not agree because they have larger plans according to you. If they have amalgamated and making larger constructions, it will be difficult probably.
They can, because in the Heritage 2, my lord, they cannot change that they cannot change, subject to question, my lord. Even if the
Mansion is a declared heritage.
Yes. Country mention.
Then they cannot.
So the Peter Cat building. So even if, my lord,
That's why it's sizzling. The litigation is also sizzling.
now, my lord, whether 39(4), if you logically consider, my lord has to consider whether the identity order of injunction, the injunction application is still pending. Because whether the identity order of injunction, my lord, comes within the, whether it is materially affected. Non-disclosure of the earlier suit materially affected the decision of the present granting order of injunction. The court, after considering order 39 rule 4, have considered that it is not a material suppression. And that fixing the injunction application to be heard.
What else?
And so what the
And they cited on the last occasion, probably cited
suppression.
2010-14.
Suppression is material suppression, my lord.
Clean hands and
Clean hands and other things. My lord, to consider each case as its own fact. Initial suit was filed for the purpose of infringement of by using the lawn. Subsequently, this suit was filed as soon as they have started construction. Cause of action for filing of the present suit arose. Even if I mentioned that I used the said lawn for the purpose, in another purpose, I'm using the same. But it does not take away my right to file a subsequent suit on the basis they are trying to make construction which practically will block by air and light. Be as it may, whether my lord, at this stage, my lord, whether, my lord, your lordship will consider minute for the purpose of adjudication of the same.
what?
Whether it will close the air and light or not, they have the proper sanction plan for the purpose of making such construction that is sufficient for the purpose. Whether that will take away and it comes within the purview of, my lord, material suppression. Material suppression which will influence the getting an order of injunction.
Could not prove the foundational fact that it will block your air and light to such an extent that you cannot survive, you cannot run the school. You can very well run the school.
Yes, then, my lord, initially, my lord, the additive order of injunction, whatever the pleadings I made, that will be turned to be true. In spite of that, my lord, if your lordship hold that 39(4), my lord, can turn to their application under 39(4).
Yes. Which page? Here's the page.
Yes, my lord. Page what? 39, 42. Page 42. Jug.
Yes. Para 5 he has placed also.
Yes.
Para 5 he has pointed out the suppression.
Paragraph 5.
Pointed out the suppression.
Yes, amendment plead
and also quoted the previous release.
After that, my lord, the petitioner states from the bare perusal of the amendment made in the plain, it appears the suit is not only barred under the relevant provision of code, but also on the specific real act. On the Easement Act, evident in any event, the issues in both the suits are directly substantially similar, instead of suit being the subsequent suit is barred by law, or any event liable to be stayed. So this was the specific amendment made. Now, my lord, kindly consider whether the cause of action of the earlier suit has materially affected the subsequent suit. So this was the subsequent. What is falling from your lordship?
Cause of action, among the bundle of facts which constitute a cause of action is your basic right to that property.
Yeah, my right is
cardinal fact of your cause of action. If you don't have a right to a property, then there cannot be any cause of action. It comes within the bundle of facts. Your rights are varying at different stages. Once you say irrevocable license, once you say air and light, again you say easementary right. Easementary right, you say it's used as a playground. That is a physical easementary right, not air and light. So you make three cases at the same time.
Subject question, if you logically consider once, my lord. Initially, the suit was filed for regarding denying my access to the lawn.
And you have completely suppressed the previous suit, which conduct is.
Yes, if that amounts to which is, my lord, each case has whether this suppression is material for the purpose of granting an order of injunction.
Why is it not?
My lord, can you consider whether that is what, my lord? Even if I disclose that filing of that
Property
earlier
is same, parties are the same.
Same. If
your rights are varying, just by varying your rights, you can say
one
that
is actionable nuisance, one is easementary right.
What is actionable nuisance?
Actionable nuisance is the blocking of air and light. It comes, my lord, subject to action, my lord, within the ambit of actionable nuisance.
This action is an actionable nuisance. This legal action.
You know? And parties external whether blocking of air and light comes within the tortious liability regarding accidental nuisance or not. Initial suit was filed on the ground of right by easement where you have grant that I have given permission to enjoy that playground, be as it may, whether I am entitled or not, that is subject of suit. Whether this construction which is going to be made, whether it will defeat my right to get access to light, air and light, whether it comes within the same purview or not, and non-disclosure of the earlier suit will influence the granting our order of injunction, additive order of injunction under Order 13 Rule 1 and 2 or not.
Order number 4 was the first order. Which, yes.
Yes.
Yes, yes, yes. The copy handed over by. So let us decide now. Ash.
If your lordship wants, that judgment কোথায় এই যেটা ডিভিশন লর্ডশিপ চাইছিলেন না yeah hand over copy of that judgment
yes what justice what is it
ওটা কই
the present appeal has been preferred against an order dated September 19 2023 whereby the application of the defendants appellants under Order 39 Rule 4 of the Code of Civil Procedure for vacating an order of injunction dated September 13, 2021 was dismissed and the injunction was extended. First of next para. Learned senior counsel appearing for the appellant argues that the initial order of ad interim injunction was obtained ex parte by suppression of material facts. First up, prior to the filing of the present suit, another suit had been filed by the plaintiff stroke respondent for similar reliefs. Push up next para. The filing of the said suit and the refusal of the prayer for injunction made by the plaintiff stroke respondent in the said suit has been completely suppressed while obtaining the ex parte ad interim order, thereby bringing the case within the fold of Order 39 Rule 4 of the Code. Which the next para, learned senior counsel points out that in the previous suit, filed between the same parties and on the same subject property, the plaintiff stroke respondent took a plea that it had a right of easement because the suit property was being used as a playground and for other purposes by the plaintiff school. Full stop. However, comma, in the same breath, comma, a mutually destructive plea of irrevocable license was also taken. Full stop. Next para. It is argued that the contradiction between the easementary rights and the license has been sought to be mitigated by filing the present suit during pendency of the previous suit, comma, by suppressing the fact of the subsistence of the previous suit, comma, by seeking now a declaration that the plaintiff has easementary right to enjoy free light and air through and from the suit property. Full stop. It is contended that the learned trial judge completely overlooked the said facts while observing that the defendant stroke appellant has failed to lay particulars of alleged suppression of material facts. Full stop. It was further held erroneously by the learned trial judge that the petition under Order 39 Rule 4 of the Code falls short of its requirement. Full stop. Next para. In the cryptic reasoning portion, comma, the learned trial judge also observed that admittedly the defendant stroke the plaintiff stroke respondent is in permissive possession of the plaintiff, comma, which is completely contrary to the records, comma, since at no point of time did the defendant admit any such permissive possession. Full stop. Next para. Learned senior counsel takes the court through the previous rejection of injunction by the learned trial judge in the prior suit, comma, which was affirmed by a division bench of this court. Full stop. While so affirming, comma, the division bench observed that the plaintiff appellant had claimed its permissive possessory right to use the suit lawn as playground of the students and teachers of the plaintiff school. Full stop. Though certain documents regarding grant of such permission allegedly issued by the defendant number 1 was annexed to the injunction application, comma, it was observed, comma, but no document was annexed to the injunction application showing that the plaintiff in fact was in possession of the disputed lawn as on the date of filing of the suit. Full stop. Accordingly, leave was granted on the prayer of the learned advocate appearing for the plaintiff stroke appellant to file a supplementary affidavit bringing on record documents to show the plaintiff's possession of the suit lawn. Full stop. However, comma, an affidavit was subsequently filed before the learned trial court in connection with the earlier suit, which is diametrically opposite to the leave obtained, comma, by reiterating that there was no document to show permissive possession of the plaintiff in respect of the property. Full stop. Next para. As such, comma, arekta learned senior counsel places reliance on the judge on namta diye reported at 2010-14 SCC 38, where, comma, and where, comma, where it was internally observed that a person who does not come to the court with clean hands is not entitled to be heard on the merits of his grievance. Full stop. Next para. Accordingly, it is submitted that the impugned order be set aside and the ad interim injunction granted be vacated. Full stop. Next para. Learned counsel appearing for the respondent, defendant number, appearing for the plaintiff's respondents, submits that the present appeal is not maintainable in the absence of any challenge to the subsequent extensions of the injunction order originally granted by the trial court. Full stop. It is argued that unless the original ad interim order as well as all subsequent extensions are challenged, comma, fact remains that even if the application under Order 39 Rule 4 of the code is allowed, comma, the subsequent extensions remain, and as such, comma, the the judgment setting aside the impugned order would be rendered toothless.
May I hand over the mic?
Full stop. Next para.
This is my copy.
Learned counsel appearing for the respondent further places reliance on the judgment of a learned single judge of this court
I have only one copy. I get it. Here.
in the matter of State of West Bengal and another versus Messrs. Encon Private Limited, comma, reported at 2020 SCC Online Cal 2287. First
2277.
2277. Full stop. Next para. In the said judgment, comma, it came up for consideration before the learned single judge as to whether, in the absence of any challenge to the subsequent orders extending the initial ad interim order of injunction, comma, an appeal against the initial order is sustainable. Full stop. The learned single judge expressed doubt and referred the matter to a larger bench. Full stop. It is pointed out that a larger bench has accordingly been constituted and is in season of the reference. Full stop. However, comma, the said reference has not yet culminated in a final order. Full stop. Next para. Learned counsel next argues that the cause of action for filing the previous suit is different from the present, and as such, comma, there was no material suppression of facts. Full stop. Next para. It is argued, comma, by placing reliance on the averments made in both the plaints that initially the plaintiff had claimed an easement right over the property since it has been used as a playground by the students of the plaintiff school. Full stop. However, comma, subsequently a signboard was put up on the property to the effect that it was under possession of a joint receiver appointed by this court. Full stop. Next para. Subsequently, comma, in the present suit, comma, it has been alleged that the defendants have started digging the suit property, comma, thereby creating an apprehension that constructions would come up on the property which would prevent the free flow of air and light to the school run by the plaintiff number 1. Full stop. Next para. Thus, comma, it is argued that the learned trial judge was perfectly justified in passing the impugned order. Full stop. In any event, comma, it is submitted that the right to free flow and of air and light pleaded by the plaintiff in the present suit has been substantiated at the ad interim stage by the averments made in the injunction application, and as such there arose no occasion to vacate the same. Full stop. Next para. Upon hearing learned counsel, comma, we conclude as follows. Colon diye niche. There are several aspects of suppression in the present matter. Full stop. Next para. The first aspect of the matter which catches the eye is that in the previous suit filed by the plaintiff stroke appellant, comma, plaintiff stroke respondent, comma, bearing title suit number 414 of 2015 before the same bench. Before the same bench of the City Civil Court, comma, a mutually destructive plea was raised by claiming reliefs both in respect of alleged easementary rights of the plaintiff for being allowed to use the suit lawn as a playground on the one hand, and, comma, on the other, that the plaintiff is a licensee, comma, which is an irrevocable license. Full stop. Next para. An easementary right presupposes that there is a dominant heritage and a servient heritage. Full stop. The dominant the person claiming the easementary right has title over the dominant heritage, whereas it does not have any title over the servient heritage, comma, over which easementary right is claimed. Full stop. Next para. Thus, comma, the moment the plaintiff pleads irrevocable license on the property that is the servient heritage, comma, the same destroys the easementary character of the right. Full stop. Next para. That apart, comma, more fatal to the plaintiff's case is the suppression of the previous refusal of injunction. Full stop. We find from the records that previously ad interim injunction was refused in the earlier suit to the plaintiff on the ground that the plaintiff is not an owner of the property. Full stop. The plaintiff preferred a challenge by way of an appeal before this court. Full stop. A coordinate bench of this court, comma, by a judgment and order dated July 6, 2015, passed in the appeal bearing FMA 1906 of 2015, comma, categorically observed that the plaintiff appellant has claimed permissive possessory right, and those certain documents regarding grant of permission allegedly issued by the defendant number 1 was annexed to the injunction application, comma, no document was annexed showing that the plaintiff in fact was in possession of the disputed lawn on the date of filing of the suit. Full stop. On such premise, comma, the learned advocate representing the plaintiff stroke respondent sought leave to file supplementary affidavit for the sole purpose of bringing documents on record to show that the plaintiff is in possession of the suit lawn. Full stop. On such premise, comma, the division bench of this court granted the plaintiff a week apostrophe time to file such supplementary affidavit before the learned trial judge and to dispose of the appeal. Full stop. However, comma, in the trial court, comma, the plaintiff went back and instead of filing a supplementary affidavit showing its possession of the suit land, comma, filed an affidavit where it admitted that the right of the plaintiff is not a right based on possession of the lawn, but it is a right based on permissive possessory right, within bracket, whatever that means, bracket close. Full stop. The possession of the plaintiff, comma, as per the said affidavit, comma, was not exclusive possession, but a possession limited to the extent which the plaintiff would require to allow its students and teachers to use the lawn. Full stop. Next para. Such pleading, comma, in the opinion of this court is akin to বানানটা পরে বলে দেবো, আপনি লিখে রাখুন নিজের মতো করে, স্ক্রডিঙ্গারস ক্যাট, এটা বানানটা আমি লিখে দেবো, স্ক্রডিঙ্গারস ক্যাট. Full stop. Next para. In the same breath, comma, the plaintiff cannot claim that it is in possession of the property for the limited purpose to allow its students and teachers to use the lawn, and on the other hand, comma, claim that its right is not based on possession of the lawn. Full stop. Next para. Even permissive possessory right relates to possession and as such does not pertain to an easementary right, comma, which only consists of user of the property. Full stop. Next para. That apart, comma, the conduct of the plaintiff is deplorable inasmuch as it sought leave from this court on the specific plea that it would file a supplementary affidavit to show that it is in possession of the property, whereas it returned to the trial court with a contrary affidavit. Full stop. Next para. The premise of the cause of action arises first from the entitlement of the plaintiff to the suit premises. Full stop. The entitlement forms an integral part of the bundle of facts which comprise of the cause of action. Full stop. As such, comma, the plaintiff retains its contentions in the previous suit to the effect that it has a permissive right to use the suit lawn physically, but adds a cosmetic superfluity thereto in the second suit by pleading that it also has a right of free flow of air and right from within double inverted from and through double inverted close the lawn. Full stop. Next para. It is clear from the different paragraphs, comma in particular paragraph numbers 15 and 16 of the plaint of the current suit, that the plaintiff sticks to its guns, GUNS, insofar as its pleadings in the previous suit are concerned, to the effect that the lawn is being used as a playground since the year 1974, and that the defendant granted permission to the plaintiff to use the lawn as an easement attached to the school premises. Full stop. Next para. However, comma, there is incongruity between the said pleadings and the relief sought in the current suit, the latter being only confined to declaration that the plaintiff has easementary right to enjoy the free light and air within bracket through and from double inverted close the said lawn. Full stop. Next para. Thus, comma, in the garb of easementary right to enjoy free air and light, comma, the plaintiff has reiterated its claim in the previous suit. Full stop. In fact, comma, we do not find any reason as to why the trial court, comma, even upon coming to know of the pendency of the previous suit, comma, from the pleadings of the defendant's application under Order 39, Rule 4 of the Code of Civil Procedure, comma, feigned ignorance of the same, full stop, it would be more appropriate if the learned trial judge stayed the proceedings of the second suit, that is the current suit, by following the principle of Section 10 of the Code of Civil Procedure, comma, since the issues involved in both the suits are directly and substantially the same. Full stop. Next para. That apart, comma, we are of the opinion that in view of the above facts and circumstances, comma, the suppression of the rejection of the plaintiff's prayer for injunction in the previous suit, and that it could not produce any document regarding its physical possession of the property despite having sought leave before the coordinate bench of this court to file a supplementary affidavit to that effect, as well as the pendency of the previous suit itself, comma, are material facts which must have been disclosed before obtaining the ad interim order of injunction in the second suit. Full stop. Having deliberately suppressed those facts, comma, the plaintiff is grossly guilty of suppression of material facts, comma, which entitles the present defendant stroke appellant to have a vacating of the original ad interim order of injunction. Full stop. Next para. Insofar as the maintainability of the appeal is concerned, comma, mere pendency of a reference to a larger bench of an issue, comma, is by itself not a deterrent for all courts for all time to come till the reference is answered, comma, to stay their hands on similar issues if they crop up in other litigations. Full stop. Such an approach would never give an end to litigation and would unnecessarily increase multiplicity of proceedings. Full stop. Next para. Insofar as the plea of non-maintainability on merits is concerned, comma, the said contention of the plaintiff stroke respondent, in our opinion, comma, is also not tenable in the eye of law. Full stop. Next para. It is the first and the parent ad interim order of injunction which is extended from time to time. Full stop. The very expression within double inverted extension presupposes that there is a subsisting something which is being sought to be extended. Full stop. In the absence of a parent order, comma, there would not arise any question of any single inverted extension, but every time it would be a fresh grant of injunction upon the court being independently satisfied on each and every such occasion by hearing parties on the maintainability and merits of the application. Full stop. It is common knowledge that while granting extensions, comma, courts do not enter into that exercise, full stop. Next para, in the present case, comma, it is the case of neither party that the ad interim order initially granted has ever spent its force or been vacated, full stop. In such an event, comma, it might have been argued that there is a reimposition of the injunction order, full stop. However, comma, since no such circumstance attends the present case, comma, we are unable to accept that a challenge to the principal, comma, parent and first ad interim injunction order would not suffice, full stop. In the event the original and parent order is vacated, comma, all subsequent extensions which are but mere offshoots of the first order and mirages of the same, mirages, mirages of the same, comma, automatically spend their force and evaporate, full stop. Hence, comma, a challenge to the parent order would suffice in our opinion, full stop. Seen from such perspective, comma, we are of the opinion that the learned trial judge acted with patent illegality in dismissing the application under Order 39 Rule 4 filed by the defendant stroke appellant in the court below, full stop. Accordingly, FMAT 542 of 2023 is allowed on contest, comma, thereby setting aside the impugned order bearing order number 20 dated September 19, 2023, passed by the learned judge, 5th bench, City Civil Court at Calcutta, in title suit number 972 of 2021, and vacating order number 4 dated September 13, 2021, passed in the said suit, full stop. It is deemed, comma, as a consequence, comma, that all subsequent orders of extension, comma, extension of the parent order dated September 13, 2021, comma, if granted and stroke or subsisting, comma, are hereby automatically vacated, full stop. No orders to cause. No application is pending.
And so for the injunction, main injunction application to dispose.
Uh,
And the observation, my lord.
Very well. Insofar as the main injunction, temporary injunction application pending in the court below is concerned, comma, the learned trial judge shall decide the same as expeditiously as the business of the said court permits, comma, without being influenced unnecessarily on the merits of the case by the observations made above. But if it's necessary, it will be influenced. We are on the basis of suppression.
Yes, that is the ground of 39(4).
Yes.
I'm grateful to your lordship for passing the last portion of the order. It is our.
You are
feedback.
fighting a lost cause. Mr. Rai, our sympathies go with you, but the judgment goes in there.